actually manage as well, which on the average is between 2 and 2.5 billion rands a year. So you're right, it's a lot of money. The procurement processes that need to follow in any of these instances. The chronology of events, number 5, between, as you said, the Constitutional Court hearing in 2012, its decision in 2013, its subsequent decision in 2014, and up to the present time, to the extent that we've been involved in this. Number 6 is how does money flow from the National Revenue Account, the South African Reserve Bank, finally to the grant recipients, because that's been quite a mystery for us to solve. As I was indicating to you earlier, even late yesterday afternoon, we're trying to figure out exactly how much of time is spent where, in how many different accounts before the money gets to the grant recipient or the beneficiary. The application from SASSA in respect of deviation from the procurement rules, and some insight into the correspondence between ourselves and social development. Number 9 refers you to the court judgments of 2013, 2014, and March 2015. There are various SASSA submissions to the court as well. And again, the SASSA people might be more useful than ourselves in this regard. And then finally, where do we stand currently? Last week, government formed a ministerial task team that has met 3 times already since last Thursday, and what are some of the matters that they are looking at. And we then round up and avail ourselves to any questions that you might have. We start on the note that, as I said earlier on, we have both a constitutional responsibility to obey the law, but at the same time, given the current circumstances, both in respect of SASSA and ourselves, there's what one senior counsel called a higher duty. And that higher duty is how do we ensure that people receive their grants on the 1st of April. And I want to say very categorically that everything that we are doing at the moment is directed at ensuring within legal bounds, and where flexibility is required, the court must determine that flexibility, how grants are to be paid on the 1st of April, and I'm fairly confident that grants will be paid on the 1st of April. The question is, what route do we travel between now and then to place ourselves in that position? As you pointed out, Chair, your invitations said that there are 4 issues we need to address. Our role in development subsequent to the Constitutional Court rulings, Treasury's understanding and observation of processes in SASSA itself, our own position and role in the current contract being negotiated, and we'll clarify that for you as to what is being negotiated and what isn't, and any other relevant information in respect of grant disbursement and the contracts that apply. The executive responsibility issue is quite important because we don't want to confuse roles here. As I said, we're just a supporting act. Prime responsibility remains with my colleague, Minister Dlamini, the Minister of Social Development, and the entity that reports to her, SASSA. And this slide essentially covers that. I think all of you have copies now, so I'm not going to read the detail if that's okay with you. And in a letter that we received dated February 8th, which we quote here, a paragraph of this point is actually emphasized, that the Department of Social Development is a sector department primarily in charge and responsible for social security, and more particularly the payment of grants. We agree with that. In our response, amongst the things that we've said is that in terms of Section 2161, which I'm sure you're very familiar with, and by the way, which should be exercised a lot more in government, the Minister of Finance and National Treasury are mandated to ensure transparency, accountability, and sound financial controls in the management of the country's public finances, which, as we know, is not always the case. So we describe our role as being fourfold. These are the 4 areas. First, as part of the budgeting process in government, as determined by Cabinet, what is the budget that is assigned to the department and its entities. In the first instance, what is the administrative budget? In the second instance, what's the budget for the actual social grants that are paid? And then what has been allocated over the years in terms of what is called the insourcing project. That is when SASSA said to the Constitutional Court, don't worry, we in the future are going to be able to develop a set of systems that will ensure that grants are actually paid. In other words, SASSA itself will pay. Secondly, we are responsible for the procurement framework, as we outline here, which essentially relies on the foundation in the Constitution in Section 217 and the various pieces of legislation, including the PFMA, the Triple PFA, and various instruction notes pursuant on that. And in particular, the instruction note number 3, which we'll refer to later, and sections 8.1 to 8.5. And these are the sections that allow a CEO of an entity to apply his or her mind in deviating from a competitive process, as Section 217 of the Constitution requires. The third is the oversight and support role. And here, again, in terms of Section 216 of the Constitution, financial management, setting of norms and standards, and where appropriate and requested advisory support and support in respect of any policy decision that a department or entity might want to take. And the fourth is, more generally speaking, what we might call national interest. In this instance, the national interest would be that we all want to make sure that grants are paid on the 1st of April. These numbers are the administrative budgets of SASSA. The projected expenditure for 17-18 is 7.7 billion, of which 7.2 billion is a transfer from the Department of Social Development, and the balance surplus funds that they've been retaining. The budget availability normally exceeds, as we point out here, spending for each of the past 3 years. So there's a buffer, if you like, that they have. And 2.1 billion rands is estimated spending on payment of contractors in 16-17 and 2.3 billion rands in 17-18. So honorable members have, Chairperson, numbers available to them now from 13-14 right up to estimates for 2019-2020, which will give you some idea of what we are talking about in terms of monies that are available. So there's no shortage of money in the system to do that which is required to be done, both administratively and in terms of payment of grants. Here is a more detailed table in respect on the left-hand side of each of the types of grants that are paid. And for that period, again, 2013-14 to 2019-20, of course, the latter years will be estimates. What are the amounts made available either in the original budget or in the adjustment appropriations? So the total budget for social grants for 2017-18 is 151.6 billion rands, growing to 175.6 billion rands in 1920. That is the outer years. The regulatory framework, as I pointed out earlier on, is built upon Section 217 of the Constitution, the PFMA, the Treasury regulations, and the instruction note that I referred to earlier on. In terms of procurement, and I'm sure we'll come back to this issue, but we quote here Section 217 of the Constitution and the relevant provisions within the PFMA, the Treasury regulations and instructions. And essentially we're saying here that in terms of the Constitution, all tenders must be advertised so that there can be a competitive process. So the key is, emphasis is on competitiveness. In other words, anybody who wants an opportunity to bid to do a particular piece of government work must be allowed to do so, and allowed to indicate what their costs will be so that government can get best value. Except where, of course, you get collusion like we had in the construction industry which Minister Patel and the PICC have been dealing with in recent times. In exceptional cases, as we point out here, deviations from competitive bidding process can be followed for emergencies, that are natural disasters, in instances where you have sole suppliers, and certain other exceptional cases. And in other instances, expansions and variations of existing contracts are allowed up to 15% or 15 million rands. These are a lot of technical details here, but they're important when you apply your minds to a particular application that might come from an entity. So our responsibility as the National Treasury, again in respect of procurement, in terms of the PFMA, is to monitor and assess the implementation of the Act, including any prescribed norms and standards in provincial departments, in public entities, and in constitutional institutions, to set out a procurement framework, which is described in Chapter 16A of the Treasury Regulations and various instruction notes and circulars. You know, bureaucrats like instruction notes and circulars, so there's any number of them, and give approvals as may be necessary from time to time if the proper processes are actually followed. Again, we make reference to PPPFA and regulations therein, and what we indicate here in particular at the top, and number 2, is organs of state must draft specifications in such a way that would provide an equal opportunity and an equitable opportunity for historically disadvantaged groups to be able to bid. Now, this is quite crucial, because often it is the way in which specifications are designed that can enable maximum inclusivity and opportunity, or narrow it down to your favorite person or entity as well. So often this is the gaming area in the procurement processes as well, if we have to be frank with you, and I'm sure some of you know this as well. The decisions from courts obviously are binding, and this sets out the obvious outcome of any court process that might be followed at a particular stage. This is the crucial one that might apply in this instance and has now begun to apply, which is Note 3 of 2016-17. And these are the 5 instances when a CEO or accounting officer may consider deviation from the normal competitive bidding process. So you can read this, but the first one says the accounting officer or accounting authority must only deviate from inviting competitive bids in cases of emergency and sole supplier status, which is what we pointed out earlier on. Second one, an emergency procurement may occur when there is a serious and unexpected situation that poses an immediate risk to health, life, property, etc. So these are, let's call it, often acts of God, as the insurance industry might describe them. 8.3, sole source procurement may occur when there is evidence that only one supplier possesses the unique or singularly available capacity. That speaks for itself. And 8.4, the same authority must invite as many suppliers as possible excuse me, and select the preferred supplier using the competitive bid committee system. So that's what you often call a closed tender process, where you select a few and allow them to compete with one another. And 8.5, any other deviation will be allowed in exceptional cases subject to the prior written approval from the relevant treasury. So this is where the relevant treasury in the national instance is the national treasury. In a case of a provincial event, it will be a provincial treasury. And we have, the accounting authority has to determine what is the nature of these exceptional circumstances. Do they apply in this particular instance as the facts were set out to you last week? And if so, how to frame the application. So what I can record here is that the Treasury, in particular the Procurement Office, has received an application in terms of Note 3 of 2016-17, and they are currently applying their minds in terms of the provisions set out here. The oversight role and the support role, or the national interest role that we indicated earlier on, what we want to share with you is that there have been various meetings with SASSA, the Department, Reserve Bank, and National Treasury on the formulation or consideration of a new payment model based on the national payment system and operational issues that might obtain when grants have to be actually paid. There also, for example, have been bilateral meetings between Treasury and SASSA. Sorry about the spelling there. For example, there was one such meeting on the 28th of July 2016, where there were reasonably exhaustive discussions about how prepared SASSA for 1st of April 2017. Now, in December in particular, December 2016, all of us became a little bit more concerned about, are we going to be ready on the 1st of April? And there were approaches to the Director General, which, with your consent, he can address later, from the DG of Social Development and with the involvement of the CEO of SASSA. And that's the instance where under number 3, SASSA, Social Development, Treasury, and the Reserve Bank met as a joint task team. So you can see the dates there, Chair, 11, 12, 13, 19, 20, 23rd. Yeah, those are all dates in January, and there were some dates in December as well. So right up to about the 24th or 25th of January, these meetings took place to consider a series of options that they had been formulating. Now, these are some of the options that task team that started in December 2016 flowed over into January 2017 came up with. There's 6 of them. So these are 3, the first 3. And again, those who have been involved in this process can elaborate on them for you should you require that. So the first option is obviously that the current service provider be asked to continue to provide these services. Now, what is of crucial importance here is to draw a distinction between the extension of the existing tender, let's call that option A, and a new tender, let's call that option B. So those are 2 different propositions. The first one, there are 2 legal opinions obtained by Social Development / SASSA in 2016, one in, I think, about May 2016, the other in October 2016, both of which are reasonably clear that an extension will be unlawful. That's option 1, option A. It will be unlawful because the court has declared this tender to be unlawful. And that if you do want to exercise that option, you have to go back to the Constitutional Court and, in a sense, get their consent that everything you've said to them before doesn't apply any longer, and you want option 1 here and option A of the 2 options that are indicated to actually apply. The second option, option B, is the alternate option where you initiate a new tender process. So just keep that in mind because we're going to repeatedly come back to that. Option 2 here is that banks that provide services to the majority of beneficiaries, in this instance Grindrod Bank, be utilized in some way. Now, Grindrod Bank apparently has accounts for each of the recipients, and there's a distinction between recipient and beneficiary. The recipient could be a parent who receives a grant for himself or herself, plus 3 children, for example. So there are 10.5 million recipients of grants, but there are 17 million beneficiaries of grants. So that's a distinction that you might want to bear in mind as well. So you could utilize that bank. The option 3, use all the banks who want to comply with SASSA's requirements and use their network to actually distribute grants. Option 4, there are approximately 60% of beneficiaries or recipients who have access to some kind of banking services in one form or another, and again, the banking option could be utilized in one form or another. Option 5 is to utilize the facilities that the South African Post Office currently has and proposes to develop. And option 6 is where the service provider for cash distribution to grant recipients who are currently using cash pay points is also utilized to complement other options above. In other words, option 6 is about combining the banking option with the cash payment option as well. So those were the 6 options that, under the leadership of the 2 DGs, they emerged with. The social grants tender process timeline and the litigation timeline is what we now take you through briefly. Again, I won't go through the details, Chair. You have this in front of you. This outlines, and I'm sure this information was made available to you on the last occasion, how the tender under consideration right now by everyone concerned, which expires on the 31st of March 2017, how it evolved from 15th of April 2011 to the 3rd of February 2012. Or in particular 17th of January 2012 when it was awarded to CPS. And of course, once it was awarded, you then move from the tender process into the litigation process, because now that award of the tender is contested, and the court processes then begin to emerge, High Court, Supreme Court, and ultimately in November 2013, the Constitutional Court decides on this matter as well. So you can see on this slide the North Gauteng High Court and the approximate dates when that court considered this matter, then the Supreme Court of Appeals and the approximate dates when that court considered this matter, and then events in November 2014 and subsequently as well. So the 5th of November 2014 is when the company involved, CPS, lodges a notice of what they call ancillary relief to what the court had previously decided and determined on the 17th of April 2014. 19th of March 2015, the matter is set down with directions, and there's a whole lot of legal details there. And then currently, as you know, there's an application that the Constitutional Court will consider tomorrow from the Black Sash, and it will also consider whether Freedom Under Law, whether Corruption Watch, and possibly even the Post Office can participate in the processes in court tomorrow. Because the Post Office has a set of proposals they would like the court to actually consider as well. Earlier on, I mentioned the money flow question. How does money flow each month from the National Revenue Fund to ultimately each recipient of grants? Just let me see, right. So the first thing to remember is, for example, in March, this current month, it's 3 working days before beneficiaries are due to be paid, which is the 1st of April. So it's 3 working days. So sometimes if there's a weekend or a holiday, it can become 5 days or 4 days or 6 days. A consideration that you would want to keep in mind as I go through this. So 3 working days before the due date of payment, money is transferred from by the National Treasury to social development, to a social development account held at the South African Reserve Bank. Social development then transfers that money to 9 provincial social development accounts, also held at the Reserve Bank. And each of those accounts and the money in those accounts is then transferred to a net bank account of CPS Net 1, CPS Net 1 then pays over that money on the. Now, all of this happens on the same day. All happens on the same day. All right? So Net 1 CPS pays that money from their net bank account into the Grindrod bank account, and then from the first of each month, for a few days, Grindrod Bank pays beneficiaries in various forms. So number 3 outlines what are those various forms that payment actually occurs. So the payment, they are those pay points that you've seen on television and elsewhere, perhaps. They are merchants' outlets, they are retailers who provide services and who house facilities that SASSA has provided. And again, the CEO, it's good that he's here. He can tell you how that works. And approximately 4 million recipients get their grants at pay points and merchants' outlets. Then there are payments made directly into bank accounts of recipients. So that's 1.6 million people who receive their grants in that way. And another 4.9 million recipients, and this is an important one, who also have Grindrod bank accounts. They receive their grants by going to the ATM of any bank that has ATMs in a particular location. I'm not going to name banks. And that withdrawal from the ATM attracts bank charges. And those bank charges are actually paid by the grant recipient. All right? So that's important. So it's a cost to the recipient himself or herself. I hope that's not too fast, but you can study it on the paper that you have. So this is the flow that we've been able to decipher from various accounts. And again, our SASSA colleagues can elaborate on that should that be required. But what's important in this whole process? Remember, the first 4 or so transfers all take place in one day. And then the money sits in the Grindrod account for anything up to 5 days on average. In 2017, we calculated yesterday, for the whole year, it's 5 days on average. So for 5 days, presumably, that money is attracting interest. So we're talking about, what, 11.2 billion rands, right? That is transferred through this chain that we described earlier on. So 11.2 billion rands at some interest rate attracts interest. And where does that interest go? We're still trying to figure that out. It should actually come back to government because it's money earned by government in a sense. Right? So these funds earn interest for CPS Grindrod. And the question is, as I said earlier on, who does this interest actually belong to? Then the issue, as we welcome the Honorable Deputy Minister, on your behalf, Chair. Now the last thing I want to do is take his job away. So as I indicated earlier, if you remember, we outlined Circular 3 earlier on in how a deviation process could actually work. So SASSA has written originally to the National Treasury on the 7th of February 2017 to formally request support to extend the existing contract with CPS to pay social assistance benefits. The NT response, Treasury response on the 8th of February is quoted here. National Treasury does not support the extension of an invalid contract and will only support the extension if the Constitutional Court will further extend the order of invalidity beyond the 31st of March 2017. So this is the option A I referred to earlier on, where consideration is given to extending the existing tender. And remember, we have 2 legal opinions which say very clearly, because that tender has been declared unlawful, any extension will also be unlawful. And if you want to do anything with that tender, go back to the Constitutional Court and obtain their permission. There was a second letter to the Treasury, the slight correction, the 10th of March should read 13th of March 2017. And this, Chair, is now in relation to the option B that I described earlier, inverted commas, a new tender, and a formal application for deviation in terms of that 8.1 to 8.5 that I was describing earlier on, submitted to the National Treasury, and of course our officials in terms of the law are applying their minds to the application for deviation. There were various exchanges, as I indicated, between the two ministries and the Procurement Office and SASSA. This gives you a summary of those exchanges. But the essence is that once we became aware of the one legal opinion in October 2016 in particular, which clearly stated what I indicated earlier about the unlawfulness of the original tender, and that the Constitutional Court should be advised of any thing that we need to do in that regard. But also a more recent opinion, also which extends the October 2016 or builds upon the October 2016 opinion, also says that the logic works like this. That tender is unlawful. Any extension of the tender in whatever form, because it is unlawful, has to be with the consent of the Constitutional Court, but also must be for the shortest possible time, so that you can get back to the principle in the Constitution of competitive tendering. So whatever abnormal activity or process you have to follow in order to make sure that grants are paid on the 1st of April, you've got to go back to the competitive process as soon as possible, or some process that is acceptable within the law. So, Chair, if you don't mind, I'm not going to take you through all of this, but it's here for the record. Letters from SASSA, or between SASSA and the Procurement Office, which also reflects some of the things that I've been saying earlier on, are listed here as well. The various Constitutional Court rulings, I've been referring to them on and off. The 29th of November 2013 is the first ruling of the judgment of the Constitutional Court, which essentially says that it wanted further submissions on the basis set out in the first dash on the 29th of November 2013, that it will be inappropriate to make a decision on a just and equitable remedy in the absence of further information and argument on these issues. That led to that being followed, and then a second judgment on the 17th of April 2014, and the order of the court, that's the decision of the court, is outlined at the top of the slide, that the contract between SASSA and CPS is declared invalid, as I indicated earlier. The declaration of invalidity is suspended, pending the decision whether to award a new tender after the tender process is rerun. So the court has the ability to say, although something is illegal, because of what we described earlier on as the higher duty to ensure that people continue to receive the grants, it can suspend the unlawfulness until a new process is put into place to ensure that there's continuation in payment of grants into the future. SASSA to initiate a new tender process for the payment of social grants within 30 days of the order. The new tender must be for a period of 5 years. If the tender is not awarded, the declaration of invalidity of the contract will be further suspended until the completion of the 5-year period for which the contract was initially awarded. Within 14 days of the decision not to award the tender, sorry about the spelling errors, SASSA must lodge a report with the registrar of the court setting out all the relevant information on whether and when it would be ready to assume the duty to pay grants itself. The principles established by the court, and this judgment is quite important, so you might want to study it in your spare time as this issue unfolds, because these principles have a great deal of import for other situations as well. So some of those principles are that the company involved in this instance becomes an organ of state and has a legal obligation to ensure that there is no disruption in the provision of grants. In other words, they just can't walk away. Now, so it says that if a state entity contracts with another, even private entity, to deliver a service, that private entity becomes, during the process of delivery of services, an organ of state, and has all the obligations of an organ of state to continue to deliver the services, and can't just say, I'm walking away from this. And that will be a matter of interest in the next day or so, as this matter is argued before the Constitutional Court. CPS may not benefit under an unlawful contract. Of course, CPS is contesting this. So essentially, it is saying because the contract was unlawful, I don't know what benefit means here, but it could mean that you don't profit from it because it's illegal in the first place. So that's the literal translation we can give it. Public procurement must be transparent and be accountable. That's self-explanatory. Now, on the 24th of March 2015, the court ordered delivered a composite order, as it is called, that CPS has only the following 5 remaining objections to the draft amended RFP. This is now the tender which arose from the 17th of April judgment. And that is in relation to beneficiaries, biometrics, and again, our SASSA colleagues are in a better position to explain this. SASSA shall effect its proposed amendments to the RFP to address the issues outlined in those paragraphs above, and to the extent that CPS still has any remaining objections to the draft RFP as amended by SASSA, CPS shall notify the parties in the court by 16th of April, now 2015, and the court will issue directions for an urgent hearing to resolve these issues. Again, 24th of March 2015, the court issued or said further that SASSA shall circulate the RFP to all parties, the court and the prospective bidders by 17 April 2015. All bids must be submitted by that date and shall award the new tender by October 2015. The parties may only approach the court or that court, that is the Constitutional Court, for further relief. These are various SASSA submissions in response to the judgments of the Constitutional Court, as we could find them. The appointment of bid specification committees on the 26th of May 2014. The second report in terms of the appointment of the bid evaluation committee and the bid adjudication committee. October 2015, third report, decision not to make an award. So this is the decision by SASSA that the despite the responses to the RFP, no tender will be awarded, and that SASSA itself will undertake the responsibility to develop, let's call it a system. Which is November 2015, the fourth report, SASSA will perform the function themselves. The court then discharged its supervisory jurisdiction. In other words, the court said, now that you are taking responsibility to develop a system to pay out grants, we don't have to keep an eye on you, supervise you. 2nd of March 2017 is the fifth report. That's a very recent one. SASSA will not be able to perform the function, as initially indicated in November 2015, and will be engaging CPS through a deviation process, I imagine. In terms of current discussions, as we saw in the media, I'm not sure what was said a week ago here, there were discussions between SASSA DSD delegation and CPS as a company, and that was prior to a deviation being obtained. So those discussions have been declared, if you like, void or null and void by the ministerial task team appointed last week. And a new technical task team has been appointed by the ministerial task team, and their responsibility is to take these negotiations further, to consider any obstacles that there might be to grants being paid out on the 1st of April, or to put it the other way, to ensure that grants are paid out by the 1st of April. And importantly, it's also to look at options for a future roadmap. How far has the SASSA development of systems gone? What can the post office put forward as a proposition? What other options are there? And then in the next month or two, come up with some conclusions in this regard. So in sum, Chair, our role was firstly in relation to, as part of the cabinet process and government process of budgeting, to provide, to ensure that Parliament actually appropriates money for administrative purposes and for the purposes of paying the grants. Secondly, to ensure that our guardianship of the procurement laws is properly conducted and that the laws and regulations are followed, as I've pointed out to you. Thirdly, the oversight role to ensure, in terms of Section 216 of the Constitution, that money is being spent in the right kind of way. And our fourth role is the national interest role, and you'll see that cutting across everything I've said, that where it was necessary for the Treasury to work with the Reserve Bank, Social Development, and SASSA, either to develop those 6 options or anything else, we've been available to do so, and we are also part of the ministerial task team as well. Thank you very much, Chair.
Thank you, Comrade Minister, for the submission. Before I check with comrades, I just want to check with the DG. Yes, Deputy Minister, welcome. I just want to check with the DG, seeing that there were about 2 meetings or so that are recorded around December. I mean, the Minister obviously could not give details. If there are any details around those interactions that you may want to talk to before I give comrades to make inputs.
It's very, thank you, Chair, and with perhaps the Minister and TM agreeing. I mean, just 1 or 2 points. I mean, one point is to make is that we worked very well with the colleagues both from social development and from SASSA, I would say, for most of the time. I mean, I was not in all the meetings, but I did 2 meetings, I think, myself, and then the rest were conducted with Mr. Mukhajan sort of leading the team from the Treasury, but always keeping me informed so that if the need were to arise for me to step in, I would do so. That's just the first point to make. Secondly, for purposes of clarification, and I think in part of the presentation we clarify this, we always interact with entities on matters like this one at hand now with 2 things in mind. The first one is that in an instance where what we are interacting on may have to come back to us in the form of one or some other application, we have got to be involved enough to provide the support that's necessary, but keep a safe enough distance that we wouldn't end up applying to ourselves, I hope I'm making sense. You know, when you are in there helping and then say an agreement is reached that apply for this or ask for this extra money if, for instance, it were to be necessary. It mustn't be that people say, but you were with us, you know that the money is needed. You can only say yes. That's one side of it. Or that we couldn't be objective because we were too involved in it, which is a very delicate balance. But we are not pedantic to and overzealous, overly cautious, but we do watch that, and you would see it in some of our correspondence. But the second issue is this, and it's a very important thing. Whilst we go with everything into the matter, and we would have views, we always try, and I hope we always get this right, never to take over the legally assigned responsibility of another entity. I hope I'm making this point clear. We get involved, and sometimes you can get too immersed in a situation, but it's always very important, and we always remind each other, and I hope we always carry ourselves in the process in a way that evinces this kind of attitude, which is that, for instance, matters of procurement in an entity, in the Treasury, they are mainly my business, save to the extent that parts of it can be delegated within the framework of the law, but I'm still accountable. The same corollary applies that at SASSA, they are the SASSA CEO's business. They are the SASSA CEO's business. They can never be mine. I can never have an illusion whatsoever that as I interact with him, I can, in the process, just take over that responsibility and make it mine. It is his responsibility. So the decisions, the final decisions are his or would be his. He must be comfortable with them. But when he has come to us for help, we would offer it, we would have ideas, we can make suggestions. They are only suggestions. They are advice. And they end there. And they are not instructions. Usually, if things reach a point where we've got to communicate something to a colleague or colleagues as an instruction, we put them in writing. And the colleagues have a right to insist that we put it in writing. So that is the way in which we were approaching the discussions on the matter at hand, with the view to try and find the quickest possible solution, given the time constraints, but which solution would still be perfectly aligned to the law at best, at worst, and at worst, really worst, as close as possible to what the law allows. So that was the...
Okay, thanks.
What he's also saying, without saying it, is that politicians must keep their noses out of procurement. In other words, I don't interfere with administrative decisions in relation to procurement.
No, I hear you perfectly well, Comrade Minister, because as I was talking, I was not thinking about you and him. I was thinking about what's happening in SASSA, my observation sitting from afar, that, and I think I'm being very objective. I think that the minister is taking over administrative functions, because I'm thinking, how many CEOs have we had during this delicate period? I'm not, but I don't want us to get there with you, because that's another department. But I want to check with comrades, Comrade Boy, Comrade everybody. How do we deal with this now? All right, let me take the first three comrades in here, Comrade Minister. I'm sincerely hoping that they will be asking questions. And then we can decide whether we take one at a time or we take three or four at a time. Yes, Comrade.
Let's thank the Minister for coming over to the committee and really giving us quite a lot of information that is quite helpful, because it's a matter of concern, not just to us, but the broader, everybody in South Africa. You see, on the Green Road Bank, NCPS, because the record that we are picking up is Green Road has not been performing in a manner as being expected of them as a bank, where there are things, because I'm talking in a broader sense, yes, there's payments taking place, but there's sadly a development that we hear from the ordinary people to say they then start asking them to pay for insurance, to start then paying for airtimes. Where does Treasury's protection come in that environment? Because centrally to me is the nature of the contract, which I thought that you would be able to guide us that what type of contract that you have ever come in contact with over this particular period. Because I'm not getting into the negotiations, but also to express the elements of concern. That's what really sparked. I can hear you. I'll come back to the 1st of April. That what is it? That is my other concerns that I would like you to comment about. But the Green Road and the CPS relationship and the protection of the ordinary people, where does that start and end with Treasury? Because there's quite a lot of issues that has arisen in this particular time. More than that, I would like you, Minister, which is very different from the rest. We've had a lot of debate about this issue, which I'm fairly aware now that CPS, I see what they're saying, what the Constitutional Court, I hear also what the Constitutional Court is saying. But CPS belonging to other entities, they are on a road of trying to sell this information of recipients to other entities. Now, if you listen to Imatis, what is the environment there and what is happening, and we just made the traffic fines and made the courts to take a total different judgment, are we on the road to that environment within the relationship CPS is beginning to establish with these entities, which is a serious concern for Parliament that you need to be able to take it up very seriously, because one, if you don't deal 17 million recipients, not in the hands of government, but where we don't know, what implication does it have for the future of our own government? What implication does it have for our democratic processes in South Africa? Because anyone who controls 17 million voters will undermine the democratic processes of South Africa, which means Project South Africa of democracy can be out of the window at any time. Come 2019, that environment. That's my concern, that's my major political concern, that where is this data and who controls it? After I've seen the experiences of the American and other countries that are on election trades now, that 2019 and nobody knowing what the recipients and who's handling the recipients, where does the protection come from Treasury? What does Treasury do within that particular environment to protect, which is a constitutional obligation that you must protect ordinarily the poor of the poorest. And that's what Parliament must apply its mind about, which I was just looking at our rules, that Parliament must develop. We have the power to investigate a scoper, and maybe learning more from you, we would have to recommend that Parliament take this matter quite seriously, because it's a security challenge. You see that you can't give away the data of South Africans. I'm saying it will have political implication, because it means whoever controls the data now of the ordinary people can win the elections without contestation. That's the broader political concern that other people have, that if such Parliament, which I don't know where does this commitment lies, than the authorization by court. If ever his agenda is different, he wants to give it to any other political party, or want to, I don't understand what his intention would have been. But what I don't understand from cabinet is that why would you allow the data, or tell us where is the data exactly? The minister said it's halfway, but from what we hear, the data is not with SASSA, our entity, and they don't have control over that data. Would you give us some reflections as they're beginning to craft out the negotiation patterns that have to take place?
All right.
The note 3, my second question. The note 3, which there's that 8.1 and there's that 8.5. Yes. Serious and unexpected. And the 8.5, Do you think SASSA has understood that environment or the motivation of the SASSA case in relation to the 1st of April? Are they ready? Have they ever provided good reasoning? Because when we were listening to them in Scopa, we have not yet been convinced that they've understood and they've appreciated the environment that we are confronted with on the 1st of April. That's why ordinary South Africans, everybody is very concerned, because we have not yet a firm statement that says this is what is going to happen. Now, if you bring in these technicalities of 8.1, the note 3, 8.1, and 8.5, when I was reading them, it seems as if they will continue leaving us hanging, not being certain from Treasury that is the matter going to be resolved. What you are saying to us today, Minister, is that you will give to the officials as the my last question, the empowerment. You see, rather than the fronting, which I take it that the procurement men can at least take us into confidence as Parliament. Is that happening within this particular deal? Because I wouldn't understand why the domestic economy is not being grown by this particular tender. It's a lot of money being given to multinational companies. What would be your view about that? Meaning, because we've drafted a lot of laws over some period. We were shocked when we learned that the ownership of Green Road or CPS is not with South Africa, it's with multinational companies. And who is benefiting? The minister, when we asked her that who is benefiting in this particular deal, we're not being able to be provided with facts. That is a huge concern again for me, that who benefits in this particular deal. Thank you.
Okay, sure.
Honorable Chair.
Comrade Kekane.
No, thanks, Chair. Mine is not directed, that is to Treasury. Actually, it is directed to you. That at what stage are we going to to request or allow, that is SASSA CEO, that is to fill in some of the gaps? Because the presentation from the minister was very clear. I understand the role of Treasury, and he indicated that there are areas. Let me just indicate one simple point. On page 21 and 22 of the presentation, I'll start with 22, where National Treasury is saying it cannot, that is, provide us with information because they were not involved. Now, for one to make an informed that is decision, it would be proper also to get some information that is from the CEO of SASSA. Now, my question to you is, at what stage are we going to request him to make a presentation, or the purpose of today's meeting is merely to listen to the Minister of Finance?
Well, I hope that's the last question coming my direction, because I'm not here to. But anyway, let me just respond to the comrade, and then now. No, we had invited the Minister of Finance and his officials. As for the CEO and his CFO, they are more of gate crushers than. I'm not even sure whether the CEO is back at work or is still on sick leave. But I think we can check with him or with them and find out if they are comfortable to respond to any questions. We can check on that. Comrade Kuno.
Thank you, Chairperson, and thanks to the presentation. But before I can carry on with my question, Chairperson, I just want to, I've observed something and I just want to talk about my observation. And I hope that we're not dealing with SASSA problem with the Treasury because of court. Because if you look at page 10, I think the minister emphasized the role of Treasury, which is different from what the court is saying. And if you would act because the court has said you should do ABCD, I would have a serious problem. And I'm not saying you are wrong, but I'm just saying if we could just be on the same par, all of us, that you are doing your job as Treasury to make sure that there's transparency and you are monitoring funds, public funds, which is your main role as Treasury. And to also say to the DG, please, when you are talking about your roles, don't be apologetic. There is nothing wrong with doing what you are supposed to be doing. We're dealing with the Auditor General every day. And what they do, they actually know the details of each and every department because they're there full time and checking on the spending pattern of each department. So I was just saying, let us be clear about that. Your role is a role, and somebody has to play this role, and Treasury is doing that. It's not because of God. I wanted to make that clear, Chairperson. That's my first point. The second point that I wanted, it's a form of clarity that I wanted to ask the minister. We were told by the minister last week that they have 16 million beneficiaries. And in your page, 17 million. And then 1 million they're getting money from the banks, and 16 million are the ones that are taken care of. But in your presentation, I don't know okay, page 26, you are talking about different numbers. So I need to understand the numbering. And I listened to her carefully. She said per beneficiary, they are paying 16 rands 83 cents, which when you multiply that by 16 million, it does not give 2.9 billion per annum. And I just want to know how do we bring the two figures together so that at some stage they have to tally. If you did maths, X and Y should be equal to Z. It's clear. It's a formula that has to be clear. And on top of that, the problem, the deviations that you spoke about, one of the deviations that I can think of is there was 3.5 million that was paid to VIP protection during the paying, when they were paying out the beneficiaries. But again, we were made to believe, or maybe it's myself only, that CPS was doing that job on its own. Now it's Green Road and all the cycle that we have talked about. My question is, we have Post Bank. Post Bank that's available everywhere in South Africa, not everywhere, but 80% of the places have got Post Bank. It's part of government, and they have almost 20 million, should I say beneficiaries or customers? I don't know what they are called, but they can deal with 20 million. Why don't we have confidence in their own systems, in our own systems that we have in government, and saying if post office does not have enough capacity, what is it that we can do then as government to make sure that post office has got capacity to do what is it CPS is doing? It has been proven, I think, as part of your presentation, that social development at the moment, they cannot do this on their own, so they still need help. But why do we have to outsource when we have our own in-source? Because if it's profit, if there's any profit, by the way, Chairperson, it won't be profit to an individual, but it will be profit to the government. That's one thing. Because I was asking myself, what is this? What does CPS has that is so different from any other company in South Africa? Now, with your explanation, I think it helps to understand that it's not even them who are doing that, but it's Green Road who are doing they are doing that job for SASSA. But the main question, just to emphasize what Comrade Boy has talked about, our pensioners, which is the people that we are representing here in Parliament, when they go to those pay points, they have to pay what you call amashonisa, in the loan sharks. They are there in a form of those green rod or whoever they call themselves. And besides that, they are also paying burial societies that they don't know anything about. If that Makulu dies today and you go to Green Road or wherever and say, give us money because Makulu has been paying, that money is nowhere to be found. But again, if you really allow the CEO of SASSA, if you take the advantage that he's here, how does CPS get the database of government? And the minister last week said they do not have database. Database is held by CPS. Who gave CPS those names if government does not have those names? And is it allowed in law to do that, Chairperson? Thank you.
All right, thanks. I'm not sure if we can still add one or two, or you, all right. Comrade Chilwane and Comrade Mente.
Thank you, Chairperson. Thank you, Honorable Minister, for the presentation. Chair, I just have two quick questions. But maybe I think today it's attendance that will ask you the question. It's just one question. Maybe the meeting will assist me, especially members from this side. Chairperson, I just want to find out, has SASSA and CPS agreed on a continuous, what do you call it? Continuous agreement with CPS going forward to the 1st of May? Just one, because getting mixed.
No, there is no agreement yet. But there is intent. There is intention too, but there is no agreement yet.
Okay. Thank you, Chairperson. And you know, then it's difficult for me to ask questions, but I will ask Minister, in terms of this intent agreement that's supposed to happen, I want to link it to, oh no, it's slide 16 on the deviation. When you look at deviation 8.1, it's where deviation can only be made if you invite competitive bids in case of an emergency or a sole supply. And when you also check 8.3, it talks about the sole source procurement, which may occur when there's evidence that only one supplier possesses the unique and singularly available capacity to meet requirements of the institutions. In my own mind, Honorable Minister, I will try to interpret 8.3 as CPS in the issue that we are discussing, issue of SASSA. But then that is why I asked the question to the chairperson, if whether CPS and SASSA have agreed in terms of this contract going forward from the 1st of April. Because one, in terms of tender processes that emanates from the Treasury regulations, is that a tender that is more than 500,000, I think, should go for bidding. And then two, in terms of deviations, if a department or entity must deviate, must get a permission from the National Treasury, And in this case, when you check, is that everything is done haphazardly because probably maybe we didn't comply with the rulings that we have, or we didn't comply with the regulations, treasury regulations and PFMA. So I wanted to, what I want to establish is that the legality point of view, in terms of the legal point, in terms of your PFMA, in terms of the bidding processes, what put us as what do I say, because it's all of us, it affects, the matter affect, it's either me and Parliament, it's affect also the Treasury. What does it put us in terms of complying with the regulations, the BDA thing? And then number two, the deviations. Because when you also check in terms of the I think it's slide 25. I'm just interlinking them, Honorable Minister. I just wanted to apologize to that. I'm just trying to link these questions. When you check in terms of the budget at bottom page, I think it's bottom page 10 as well. I spoke about 10, yeah. The deviation is 16. In terms of their budget, 30 plus minus % of SASSA budget goes to contracts, and 70% goes to service delivery. So when you try to do the mathematical point of view, is that then it means in terms of this contract that is the intention to sign that contract with the SASSA, then it will take out the whole money of the department or entity as it is, then it will affect service delivery. And we just want to find out on how does the deviation and the role of Treasury help in this regard. In terms of Chairperson, my second question. In terms of the options, what is this option? The options which was agreed by the, yes, the 6 options. 18 and 19. Page 18 and, yes. There were options in terms by the joint meetings which were held. Option 1, I can see, and then option 3, there's this other one that talks about South African Postal Services, SAPO. The minister last week when we were meeting said that SAPO is not ready to disperse the grants, and I think by these options, the one that is option 5 that the joint task team has agreed is that the strength of SAPO can deliver a certain element of the payment system over a period of time. So I just wanted to get a clarity in terms of this option in relation to the response that we have had. I think it's of public knowledge because the minister said it publicly. I don't know because Reserve Bank might not be here, Chairperson, but I think the minister on their behalf will be able to assist in that regard. For now, those are my 2 questions. Thank you.
All right, Comrade Mente.
Thank you, Chairperson. And thanks to the Minister of Finance. Now, firstly, Minister, you are referring to the deviations as one of the options that might be utilized. As I'm seated here, I'm of the view that deviations are of emergencies, and those emergencies are often, you said it yourself, acts of God. And now we're sitting here facing a situation which is not an act of God. It is an act of an individual who refused to understand the law and who refused to follow the proper procedures. And now we are finding ourselves in a situation where we have to consider a national interest. But we have an individual that has been holding an AK-47 into our heads. So let's just say this deviation is considered. Is Treasury going to give this money to the very same people who have no desire to create systems within the department so that the Department of Social Development with SASSA can deliver the grants to the people on its own? There is no desire at all. On the 28th of February, we had a meeting here with SASSA, and the program manager clearly said they might have systems by 2019. And you are mentioning that you will only allow a deviation in the case where the time frame is very short. And I don't see it being shorter because now 2017, 2018, 2019, it might still not happen. So are you going to trust the very same people with that money? Are we going to fall into a trap of people that create a situation and then makes it an emergency? Number two, when I look also into the same deviation, when I look at page 29 of your presentation, no, not page 29, where is that? Page 21, where you are giving out the tender process timelines. If my calculations are correct, Minister, it took 10 months. And therefore, that's also, it doesn't fall into a scope of a shorter period if we were to consider a deviation, because a new tender will take at least 10 months for it to be finalized. And we still have the very same people who have no capacity to have systems, who do not have a desire to change the system from CPS. Now, upon receipt of the first letter, Minister, I understand you gave it to the DG, apply your mind, they responded. We cannot do 1, 2, 3 before because it's unlawful. You need to go back to court, constitutional court, and follow the procedures. Then they write to you again. I just want to find out from you, Minister. You're mentioning a bilateral on the 28th of July. Were you involved in that bilateral meeting? Or was there any time last year or this year when you realized that there is a crisis looming, where you have met with the Minister of Social Development, or perhaps met with some parties that are involved, including the President, just to find a way to keep the situation, or else try to direct that you need to follow a proper procedure? You can't do this in any other way. Then, lastly, Chairperson, on the Green Road and the interest that it gets out of the money which Treasury sends to them. One, they benefit. Now, it's very clear why the CEO of Green Road, of CPS, was so arrogant in an interview last week when he was asked a question, why are you jumping from 16 Rand to 22 Rand? The CEO says, no, that's according to CPI. And seated here, I do not understand those calculations. What kind of CPI is he using? Which will allow him to say, if SASSA wants to use me, they will pay 22 rand. And seated here, it gives me information that he knows he's the only person available or the only alternative to this South African country to give out grants for whatever reasons, whether it's a deviation or whether it's an extension. And that assurance or that confidence which the CEO of CPS had is granted to him by the department itself. Why did the department go and have a meeting with them with the intention of getting the prices and extension? So, Minister, here we're dealing with a situation that is not so, it's not vague, it's a very clear cut. That someone is busy driving this vehicle into a ditch, and all of us, we must just go blindly. We must just all follow the person and go into a ditch. Also, Minister, please, can you assist us with this 22 rand? Will you allow a situation where CPS is being paid 22 rand per person from 16 rand? That's a daylight robbery. Thank you very much.
Right. Comrade Minister, I think I may as well take all my comrades so that they all would have had their bite. I think that would be fair. Yeah.
No, thank you very much, Honorable Chair. I just want to say at the outset, thank the Minister and Treasury for what I consider to be a very thorough breakdown of the realities that we are confronted with. I think we leave here, at the very least, wiser in terms of what we are confronted with, at the very least on the basis of facts, in terms of where this crisis actually is. And Chair, secondly, of course, one must be cautious not to try and micromanage social development when they're not here. And so, but Minister, as you said, the Oscars, any main actor is as good as the supporting actor to give that support. Chair, I'm going to ask very pointed questions.
Sure.
The first question is, in terms of the current budget realities that the country is faced with, and we all know that the Minister was very frank in the budget speech about how we need to put needs before wants. Is there additional funding available for the daylight robbery, which my colleague has referred to here? Because the budget has been made and allocated, and now we are confronted with the threat of a ungodly escalation, which seeks to milk the fiscus. CPS is a bunch of crooks, Minister. I want to put it to you. They are thieves. They've taken money from people for airtime, funeral cover, and all sorts of other things. People receiving reduced grants. Every day there's an outcry. So they are robbing the people and robbing the state. So the question is, do we have money for this now, new arrangement which is being put out there? Secondly, of the 6 options that were put together by the task team, which one did Treasury find most favorable? Or which combination did National Treasury consider to be a combination which would take us out of this quagmire? So when are the options listed in a order of preference? If not, but of those 6, which ones did National Treasury consider to be the best solution to the problem that we are currently faced with? I want to check, does National Treasury consider this to be an emergency in the colloquial sense of the term, in terms of the deviations which are provided for, the instances for deviation? Because I think it's important for us to also gauge the mindset of Treasury. Because as far as I'm concerned, you know, on Friday a baby was reportedly kidnapped in Durban, only to find that the mother is part of the people who had the baby. So all of us went into prayer mode, went into panic mode, and national anxiety prevailed, only to find that the mother had the baby all along. I see that to be the exact same thing here, where we are being put into panic mode for a deliberate act, a failure to lead, and a failure to comply. Because, Minister, my biggest challenge is that whilst the Constitutional Court may have made the pronouncements that it did, of which all of us are bound to agree that the contract was illegal and the contract was invalid, but the bottom line is the contract was bound to expire anyway. Constitutional Court or no Constitutional Court, the contract was bound to expire. Now the question that is at the forefront of my mind is on contract management, and whether when SASSA made the commitments that they will take over the grounds, which we all know now as a blue lie, fabrication of the highest order, but that contract management, what assistance was provided by National Treasury to guide the tendering process? Because this tender took over 2 years, and last week we were told here that it is abnormal for a tender process, and the procurement office may assist as well. It exceeded 90 days. It just became an open-ended arrangement. No, we'll take as long as we can and delay the process as long as we can. Because my view is that prevention is better than cure. So we have now arrived at this situation. So I want to actually get to what extent was National Treasury engaged? What advice did you give to guide that tender process, which in the final is a botched tender process now? Chair, as I round up, the capacity of the South African Post Office, in the view of Treasury, does the South African Post Office have the necessary capacity to actually deal with the dispensation of these grants, and then to say what type of assistance can then be given to build capacity? I think that's the important thing here, Chair, that we want to build in-house, and when I say in-house, South African capacity. Okay. We can't have a situation where American, Australian companies are milking billions and billions of rands out of our country for what could ultimately be a very simple exercise of the disbursement of funds. Finally, Chair, Minister, you have, you raised eyebrows when you drew us to the fact that the money sits there for 5 days, 11.2 billion rands, gathering interest. For who? For the why? For the Ngoba, and really, Chair, for what? So we are making money within making money. So, Chair, I want to then get, is there a possibility of us entering into a discussion with the banks? They are cited as an option to exempt beneficiaries and recipients from that the bank charges, really to go and charge to charge a bank charge of 300 on.
Just hang on, please, because when you had the opportunity to talk, you want to be listened to. So let's allow him to talk and be listening.
Thanks, Chair. So, Chair, to provide that type of exemption, because I think ours is to cushion, the challenges of our people, alleviate them. Now, if you're going to charge, if a child grant is 380, and you go and charge bank charges on that as well, yet we are saying we want the banks to assist, what models of to subsidize those charges can be brought forward? Because at the end of the day, we need to speak in the interest of the beneficiaries, of the recipients, against a system which will seek to make money out of the beneficiaries, and they have to shoulder the cost. Chair, let me just conclude by saying, Minister, whatever happens, I would find it to be a great injustice to our people if CPS continues to be the service provider in this instance. One member of parliament, Chair, his mother passed away 2 weeks ago. She was 80. She had been paying to these bogus funeral parlors since 2004. When they went to claim, believe it or not, that bogus funeral parlor said the benefit due to you is 1,200 from 2004. And because he had the capacity to go and challenge that with a lawyer, he was able to get a fair amount to him. What happens to those beneficiaries, those recipients who do not have, that legal muscle, access to legal recourse to challenge this giant of a thief, CPS, who is able, because we're giving him billions of rands, was able to challenge the system at every court with every legal opportunity. So when Treasury's responsibility is for us to receive service providers who, one, have got the capacity, but in the final analysis must also ensure that those service providers act in the national interest and act on behalf of the people. So I plead on behalf of those people, do not give us CPS. They are a bunch of thieves, crooks, who are hell-bent on milking the system and abusing our people.
Okay. Tim?
Thank you, Chair. Chair, I'd like to echo the comments of my colleagues by thanking Treasury for being here this morning and also for bringing your A team. Certainly all the right people are here, hopefully for the right answers. Just in regard to the CEO of SASSA being here, I'm glad he is here. You must know that he will still account to us on 1.1 billion rands worth of regular expenditure, but that will be for another time, so your time with us is not over, sir. I'm also glad the Treasury are here, sir, because, Chair, because some of their questions may be able to answer them. Minister, I'm going to deviate from making speeches and I'm going to ask questions. And my questions generally are to the point, and often I require simple yes or no answers. Or so you'll have to, please take note of the questions, but you don't have to give long responses. So I can spare you that. I'd like to go back to 2013, Minister, and this can be anybody in your team can answer who's well placed to do this. I do understand, Minister, that you're not operationally involved in every single aspect of finance, as you shouldn't be. So, you have a very good team here, and I'm sure they will assist. Right, so 2013, at this stage, the Minister of DSD established an advisory committee. This was after SASSA decided they were going to go on their own. So my question is various members of community were appointed onto that particular advisory committee. One of them was Dr. Makosi Koza, a current sitting MP. She was then an MPL. She received 500,000 rand for the first part of the contract, and she received 500,000 rand for the second part of the contract. She did not declare the second amount or the first amount in her members' interest, and certainly not her members' interest here. She declared receiving transport compensation. I would just like to ask a question from Treasury. Do you feel that's appropriate? That's question number one. Question number two is, the Minister then wrote, after the advisory committee had done their work, she then wrote a letter to Virginia Peterson, and she indicated, I have the letter here and I can quote from it. The letter reads as follows: I've decided that in order to roll out implementation process diligently, we need to retain the collective knowledge and institutional memory of key members of the committee. Given their knowledge and expertise, these members will lead the work streams and will work jointly with you and SASSA executive management teams so as to ensure the various work streams are adequately resourced to execute their respective mandates in a speedy manner without any disruption and to minimize delays in implementation of the third recommendations. The letter goes on to say, to this end, and this is the important part, to this end I've decided to retain the services of the following individuals who were part of the committee for the implementation of the third recommendations. Mr. Andile Nyonya, team leader, Mr. Tim Sukazi, Ms. Tankiso Pakis, Mr. Sizwe Shazi, and Mr. Patrick Monyaki. All right. So now, that was the instruction from the Minister to appoint members of the advisory committee as leaders of the work streams. Now, I know Mr. Human, I'm sure will be aware of the entire work stream story. The question is was it appropriate, number one, for the Minister to instruct the CEO to set up the work streams like that? Because surely she would be predetermining who got the work. Because that went along with the companies that got the work stream work. And as we know, that amounted to 47 million rand in the end, a sizable amount of money, and certainly above the 500,000 rand threshold. The second question is, does Treasury believe it's appropriate that members of an advisory committee then get the work? Because effectively they're advising the Minister to give them work. So the appropriateness around that scenario. Then I have to take, you know, this was an engagement today, and I'm glad it is, but I have to take issue with Treasury. Because in the report that you so kindly gave us this morning on page 30, in terms of letters with DSD, SASSA, and OCPO.
Which page?
30, 30, Chair. The third item down, the second half of the page, letters with DSD, SASSA, and OCPO. The third item down was 23 June 2016. The essence of that section is that the Office of the Procurement Officer approved the deviations. So to give that context, the Minister wrote a letter to the CEO predetermining whom had got the work stream work. The letters after that from the CEO to various other parties, in fact to the BAC, said, the Minister has asked this, please make sure it is so. You know, please heed the declaration. Okay, please heed the instruction. The BAC then responded saying, yes, we will do so. And they refer to procurement policies they have. My concern with the pronouncement of the OCPO is how on earth could you possibly approve that or give that condonation? Because it starts with the Minister predetermining who gets the bids for 47 million. There's no competitive bidding process. And I don't see any reference to the PFMA in there. So if you could just please give us hopefully a very good explanation. And then also I note in that same section there, you say that you raise the concerns, which are whether the consultant rates were assessed for reasonableness, okay, and whether the potential bidders were not discriminated, whether other potential bidders were not discriminated against. Now, those are two very, very salient concerns, and clearly the answer would be reasonableness was certainly not looked at because there was no bidding process. There was no BEC. It just went straight to BAC. And certainly there were no other potential bidders, so they, they could not have even been involved. So how can your office, with the greatest of respect, and I know today's a friendly engagement, say that you're okay with that? And what is the status on those concerns? Have you changed your mind? Or are you still very, very concerned? Okay, so that handles that. Then I'd like to get to the issue of receivables. Last week, the Minister of DSD indicated that she didn't want to do work with the banks because Standard Bank reportedly, according to her, owes SASSA 500 million rand, and Itala Bank owes SASSA 1.1 billion rand. Now, I'm sure that would pop up on receivables somewhere. That's a sizable sum of money. Is Treasury or the AG aware of such receivables anywhere on these books? I see that the AG representatives here are the ones specifically dealing with social development. So if they can perhaps comment, because I'm just trying to test the validity of that statement by the Minister. Itala the day after denied it. So if we can just get the facts there, because that was the rationale for not using the banks. So I think it's pretty important to clarify if that's true or not. Then, my colleagues have covered this partially, but I just want to, another statement that was made by the Minister last week is that there were numerous meetings held by SASSA and that Treasury were invited. And she said, but Treasury didn't come. Now, the Minister, your presentation indicates that you've tried to be as involved as you can. Can you please confirm for me, whoever is well placed to do that, were there any meetings where you were invited by SASSA to be involved in working out the solution to this problem where you simply just didn't pitch, you didn't arrive? And that's pretty much a yes or no answer, you know? And if you didn't, if it's a no answer, maybe you can tell us why you weren't there. Then the next question, and I'm winding up now, is very simply, have you ever been presented with a financial model by anyone from SASSA's side, a payment model? Have you actually sat down and said with the relevant people and said, okay, this is where we are, this is what we're doing? Or are we literally still waiting for this court decision? Has there been any negotiation, discussion, even pending, you know, with the understanding that pending the court decision, this is what we can try and put together? Has any engagement like that happened? And I know it's a tricky one because Serge Bellamont said in his stakeholders meeting on the 10th of February this year, the transcript of which we have because it's a public company, he said that there have been numerous conversations with SASSA and CPS in the past, but these conversations were kept secret because Treasury wouldn't understand the complexity of the issues, which frankly I think is a bit insulting to yourselves. But because I'm sure you can understand the complexities. Anyway, you know, so it just begs the question, has there been any meaningful engagement on this to try and find a solution? And then finally, my final question, it doesn't relate to CPS, but it relates to something else very important. In our engagement with SASSA, and just I'm using the opportunity because you're here and I'd like to get an answer on this. And maybe Mr. Human, you can help. In our engagement in November, we discussed a payment of 316 million rand to CPS by SASSA. At the time, it was initially, SASSA asked for condonation of that amount, which was granted by Treasury. Treasury then came back and said, now hang on a second, we've got some issues, and set a set of questions. That was then declared to be irregular expenditure. Then I believe there was a to and fro, and some more questions were asked, and then Treasury was going to come back with a final statement on that. And Mr. Plaatjes at that time, I believe, mentioned that he believed that Treasury was on the brink of declaring that fruitless and wasteful expenditure. So can we just get an update on that, please? Is it now irregular? Is it fruitless and wasteful? Has it been condoned? What is the story on the opinion of Treasury on the 316 million that was paid by SASSA to CPS, I believe, in 2014? Okay, thank you, Chair. That's everything from me.
Okay, Ross? And then
Thank you,
after
Chairperson.
him, we can then respond to the issues.
Chairperson, just to check with the Minister, whether the Minister and his delegation agree with me that we are currently facing a crisis in SASSA with regards to unaccountability, perhaps a crisis with regards to the lack of credibility, and then ultimately, as we sit here today, 7 days ago there were no contract. Currently in this country today there's no contract. Are we also facing, and would you agree with me that we are facing a crisis in terms of uncertainty in the country, especially for those people depending on the grants? And I've noted from my colleagues their concern with regards to this, but I would like to talk to the interventions of Treasury with regards to the timing of your interventions. You see, Minister, since 2014, the court ruling was that the contract is illegal, it's unlawful. And if I look at section 85, chapter 10 of the PFMA, there's certainly an obligation of the Minister of SASSA, the Minister Dlamini, to make regulations prescribing to the manner, form, and circumstances in which allegations and disciplinary and criminal charges of financial misconduct must be reported to National Treasury. Now, in my view, when there's a court case that finds a contract to be unlawful, it borders on criminal activity, it borders on irregular expenditure, and then it should be reported to National Treasury and the AG. Now, my question is, did the minister perhaps report those misconduct in terms of the supply chain management in 2014 to Treasury and also to the AG?
Just a minute, Ross. I had made a request that let's switch off our cellular phones.
Sorry.
And it's members of the committee who sit here and complain about non-compliance. I'm making a simple request. But we have stopped him because there's a phone ringing.
What we find in this regard, Minister, is financial mismanagement, incompetency, the non-compliance of legislation, but also the disregard for a court finding by Minister Dlamini that has stunned the nation. And this, I believe, should have been reported even in 2014 to Treasury and the AG. Let's just make sure whether the minister has fulfilled that obligation, and if not, whether she's then in breach of the Public Finance Management Act. The current situation, as I said, is still a crisis in uncertainty. The disregard for Treasury, I would like to ask you, Minister, at any stage, did you have a personal interaction with the minister? Did you speak at any stage face-to-face with each other? And also noting that there was several interventions also even from the legal advisor from the President, advising to the contrary to legal opinions from Mr. Trengrove. Mr. Hully had an opinion that we should continue with the CPS. And it's very difficult to gauge what the intervention then of Treasury should be in this regard. How difficult that intervention, did it put you in a very precarious position? And what would your views be with regards to the interventions of certain and several legal opinions in this regard? The new technical task team, Minister, it's interesting to note that there could be consensus with regards to the technical task team. I would like to know with regards to the deviation, which is key in perhaps resolving the irregular expenditure for the future. Is there currently a consensus in that technical task team that you will approve the deviation as you speak? You've met with the technical task team. Or are you awaiting the court verdict of tomorrow? And then lastly, perhaps what to a certain extent petrified me last night is to see that the submission from SASSA to the court indicates that there's a request for an oversight role with regards to the public protector's involvement and the AG involvement. I'm not sure if they did include National Treasury. And is it not the primary role of National Treasury, and specifically the procurement officer in National Treasury, to evaluate the contract? And then also the application in terms of the cost to the contract and financial matters in the contract. I believe that the contract would only be submitted 20 days as from yesterday, if I understood the press statement correct last night. What is the position with regards to the supply chain management of Treasury with regards to these uncertainty created by this application of yesterday? And are you waiting for the Concord to pronounce before you can make any meaningful decision and give us any guidance as to the validity of the new contract and whether that could perhaps be irregular expenditure be avoidable, noting that irregular expenditure in the last year ballooned from 24 billion to 46 billion. And this is what we are working with in terms of our Public Finance Management Act to see if we can reduce irregular expenditure, which could ultimately lead to corruption. I thank you.
All right. Thanks very much, comrades. I'm sure two things, Comrade Minister. I'm sure after your responses, if comrades still have a few areas to seek clarity on, we should allow them to. The second part, comrades, is to indicate that the minister, I think, and the DG have some time constraints. They're supposed to leave tonight for Germany. Yeah, I think so. So the sooner they are released, the better. Safe to say, Comrade Minister, maybe 2 points from me. One, the joint task team. What happened to the joint task team? That's number one. Number two, the current ministerial task team, which has voided all previous engagement with CPS. I would read into that to mean that Cabinet is actually saying whatever SASSA and the department were doing was actually a waste of time. And politically, it's a vote of no confidence on the minister, because I would imagine government enters into contracts every day that does not require a ministerial task team. For Cabinet to have reached that decision, I mean, what was the basis? What are the concerns? What are the worries? What are the observations in terms of the current process? I also agree that maybe let's talk to this Green Road bank and the interest that it accrues out of the monies that are paid to it. Very sinister. They make money out of those interests. They make money from these crooked deals that they have around airtime, funeral schemes. It's incredible. It's incredible, and I know that CPS just does not respect government. And if it was the time of slavery, I would say it's a slave mentality. I don't understand how you want to stick to a company that clearly demonstrates disrespect for government, and somehow you don't want to get out of that. I just don't understand the politics behind it. Or when you are in cabinet and you discuss these things, how do you discuss the politics around the fact that you have this company that has demonstrated, behavior that does not respect government, does not respect the public? It is totally a parasitic kind of relationship and attitude. And also the issue of the charges. My understanding is that the 16 Rand 44 cents was charged to also take care of the infrastructure that the company had to set up. And that infrastructure has now been set up. What then will be the basis to actually expect more money from government? And lastly, I see in the other file that were given, the letters that you wrote to the minister. I would be interested to hear your articulation of the last paragraph on the first letter. Your observations and concerns, which I articulated, about the role that the minister seemed to play in relation to administration, in relation to procurement. And to say, in that situation, is this not the cause of the fiasco we're having? That is the political hand in the administrative process. Is this not the source of this movement in cycle that we seem to be having? And that if that is the case, then therefore, that it is the minister then who should be held personally accountable and not Magwaza as the CEO. And in the second letter, I think the second paragraph to it, your concerns about the fact that from the very beginning, the approach of SASSA and the department is to start with a single option. You start with a single option. It then takes us to what one of my comrades here spoke to, that we're now stuck with SASSA. It then appears that right from the beginning, there was no intention to look at any other option but at this specific option called CPS. And it might be interesting to find out what the responses were from the minister in relation to this, to these observations, which I find very, very grave indeed, because they imply that our administrative problems are actually political. It is the political noses getting into administrative matters that creates all the problems that we're having. You look at Inatis, who is in court for Inatis. It's the same mess. Billions of rands, critical national security information in the hands of a private company that is showing the middle finger to the state. Contracts worth billions and billions of rands. We now have the Prasa debacle also playing itself out. So I'm just saying these observations are quite grave and telling. It will be interesting to check how the response from the other side were. Thank you very much. Comrade Minister.
Thank you, Chair. Let me attempt to sweep through as many questions as possible, and then if you agree, my colleagues will play wicket-keeper, so to speak, and add. And in other instances, they know more than I do about some of the issues raised. I think the first point we want to make is certainly that we want to, as soon as possible, remove the sense of uncertainty and crisis and give the assurance to the 17 million beneficiaries of the social grant system that they will receive their social grants on the 1st of April. It is for this reason that the ministerial task team was set up. It is for this reason that you now have a technical task team. As you know, Minister Hadebe chairs the ministerial task team. And our objective, as I said at the outset, is to ensure that our higher duty to the South African public is executed in the right kind of way, as far as possible within the current framework of the law, and where that framework might be constraining, then we must get the courts to agree with us that as a so-called interim or temporary measure, certain things have to be done to ensure that the payment happens on the 1st of April. So a combination of the political process and the judicial process within the next, I think, 5-6 days, hopefully, will give us absolute certainty about the payment. And we must all have that as our common objective. We will then have to sort out who's responsible, why, what happened, and so on. But our first objective needs to be on the 1st of April, that money must be paid. There's enough time thereafter to get to either some of the facts that we are asking for or some of the explanations that we are looking for, or in your case, to establish who was responsible for what, because that's your job, not ours, if I may say so with great respect. So if we can just remove this, this issue which pervades many of the questions, and certainly from our side, we will do whatever we can to contribute to this. I'm sure there are many within SASSA who have the similar objective, and then in the government system more generally as well. So that's the first point. In response to your question, the joint task team, I imagine you're referring to the December process that the DG was involved with. In a sense, that will transition into the new technical task team, and their work will be taken over by, and some of the personalities will be the same as well. And as you recall, I said earlier on that task team must now explore, firstly, how do we make sure payment happens on the 1st of April? Secondly, set up a negotiating process for whatever way forward is determined through the deviation process. And thirdly, to ensure what's the most appropriate model. And that appropriate model must consider all of the options that the honorable members have talked about, whether it is a bank, many banks, post office, a combination, all of those possibilities must be considered. And if you call the CEO of the post office to appear before you, he will give you some insights into his thoughts on the matter and assurances about what they could deliver in X months' time as well. but I don't want to speak on their behalf. I think it might be interesting for you to actually do so. When you say that we've had to void the previous negotiations a few weeks ago between SASSA and CPS, that's purely on the legal basis that a procurement process needed to be entered into first. In this instance, an application for a deviation in terms of that paragraph 8 that we had outlined for you. And secondly, arising from the outcome of that deviation process to then get down to the next question, which is what's the mandate of the negotiating team? In other words, what's the money numbers that we will be looking at? And thirdly, what are the outcomes that we're looking for from the negotiating process and conduct the negotiating process as well? So that's the process that is intended by the ministerial task team. I'm not going to pass any political judgment, if you don't mind. I leave that to you in terms of the facts that have been put forward. On the Grindrod issue, I must just raise one caution. We are merely asking the question. If the money is sitting in an account for 5 days, it should be accruing interest. If it is, where does that interest go? So we need to establish that fact. We're not making any assertions as this at this point. Yesterday, as we were trying to follow the step by step, we began to discover that there is this 5-day period on average. They might be shorter in some months, it might be longer in other months. CPS and its behavior, in particular of its CEO, many of you have commented on that. Ideally, I should not be commenting on it. But I would certainly send a message to the shareholders in Net1 CPS that the shareholders should ask some tough questions about the public utterances of the CEO and some of the gross statements that are actually made, and that it's your perception that they appear to be extremely arrogant and disrespectful to government, from which government they make 2 odd billion rands in terms of the contract that they have. So the shareholders are known. Some of them have been named and questions have been asked. Is that the conduct they want to identify themselves with? Is that the brand, if you like, that they want to earn through this particular interaction with government? And I don't think that we are involved in child's play here. We're talking about 17 million people who depend on these grants on a day-to-day basis, as we all know, for their own welfare and well-being. On the question of 1644 and the infrastructure setup, I think SASSA is best placed to give you more details in this regard. It's a logical question. If you spend 5 years developing, and even the period before that, some kind of infrastructure for payment, what new needs to be done? And if, in particular, the legal advice is that, given the invalidity of the initial tender, any new interim arrangement must be for as short a period as possible, what new costs need to be incurred in order to prosecute the new mandate that you might actually get. In relation to the letter that you referred to, I think the point we're making there is to share amongst colleagues that procurement is a business of officials. And whether you are in a municipality or whether you are in a provincial government or in an entity, that dividing line needs to be clearly understood. And if we respect and understand that dividing line, we get ourselves into less trouble at the end of the day. And we show greater respect both for the law, for the use of public funds, and for procedures that have been outlined in terms of good governance within any institution as well. In terms of SASSA pursuing a single option, again, those who've made that decision must explore that. All we were saying is that at a moment like, say, early December, when we became more integrally involved through our Director General and other officials, and considered and evolved those 6 options that we've actually put before you, you need to look at all of those options and see, on the one hand, which is the most effective in getting across the grants to 17 million beneficiaries or 10.5 million recipients, and secondly, which is the most cost-effective way of actually doing so. And that would clearly be the mandate of the task team when they get into negotiation mode. Honorable Ross, and I've addressed the question of crisis. I'm going to ask for help from my colleagues about whether we had a report in terms of the PFMA on the invalidity of the contract. I'm not aware of that immediately, or we might have to research it and come back to you. So there were several colleagues, honorable members, that asked questions about our involvement, which meetings we attended, and so on. Personally, I was approached in early January at an ANC meeting by the minister to say that we need to discuss this matter. And then I was given access to, or given 2 legal opinions, and I think 2 documents which outlined the new system, if you can call it that. And then a series of interactions over the telephone and by letter began to be initiated, including interactions amongst the officials themselves. The President did convene a meeting, and he issued a statement after that, I think 2 Saturdays ago, at which the 2 ministers were present and officials, and where we briefed him on developments to date. And of course, subsequently, the ministerial task team was established, which took over that function on a more collective basis. Mr. Ross asks, has the task team approved the deviation? As my colleagues will explain to you, nobody other than the officials who've been delegated that responsibility in the Treasury makes that decision on the basis of information before the officials. So neither I nor any technical task team outside of the Treasury can say we decided that you shall give the deviation. Those accountable for that process, working under the Director General of the Treasury, will ultimately make the decision on the basis of the information that they have and the reference to the right part of the law as is actually required. On a point of clarity around the oversight role, I'm not sure if it's in the pack that you've been given, but the Constitutional Court, I think last Thursday or thereabouts, issued a set of questions and asked the Minister and SASSA to respond to those questions. And amongst those questions is, what is your view about who should play the supervisory role? It's in that context that the Minister and SASSA have responded and said that they will propose the Auditor General, the Public Protector, or anybody else that the court might suggest. If I remember, that's the response that was given. So the question of oversight is that the court can decide on anybody else that they would think appropriate. Yeah, it's quite strange that CPS says that details on anything might only be available 20 days after. Well, shall we just put it in the strange box and leave it there for a short while until we can answer those questions better? Forgive me if I get the pronunciation wrong, Honorable. Is it Brotuset? Right. Yes, no. But you did make lots of statements to it. If I may say so with respect. I think several of your questions were directed to the phenomenon of the advisory committee, the transition to the leadership of work streams. I'm not familiar with all of those details. If some of my colleagues are, and to the extent they are, they will give you that information. And the matter of Dr. Koza is really a parliamentary matter, which the Ethics Committee should consider if you think that's appropriate. I don't think we are in a position to give you an opinion on that. So your question was, it appropriate for the minister to predetermine? If there was predetermination, no. But let me see what information we have in the rest of the delegation that would help you with that. Was it appropriate in any other situation? I'm going to add those words for just transitioning from one type of role to another type of role where a competitive process might be required. The answer is clearly no. You then make reference to slide 30, so the relevant official will respond to that. Then your point about receivables, I think that my colleagues will add to this as well. The issue here really is that there are bank accounts, money was paid into those bank accounts that belong to people who are receiving grants, but those monies were not withdrawn by the people receiving the grants, so the money sits in that particular account. And I think there are similar phenomena elsewhere, in pension funds, for example. So if you talk to the Financial Services Board, they will also tell you there are lots of unclaimed benefits that lie in different types of pension funds. And how you balance making sure that the money remains there for those who might want to claim it versus using it for some other purposes until they claim it versus bringing it back into the National Revenue Fund, if that's relevant, is the dilemma that we often find ourselves in. But let me see if the technical people have more insight into those processes. Invitations to SASSA meetings. Again, I'm not, I don't attend these sorts of meetings, so my colleagues can fill you in on that wherever it's appropriate. Now, when you talk about, Honourable Member, the financial model, I wanted to get some clarity from you in terms of payment on 1st of April. So that would depend on the deviation, the negotiations with the CPS after the deviation decision is made, if it is approved, and thirdly, anything the court might say as well, because there are strictures that the court has placed in the April 2014 judgment that will have to be taken into account, which it might vary or it might not vary. So I think let's wait for the court decision, and that will give us some clarity. And CPS, of course, is making its own claims and staking its own claims in the public domain as well. The 316 million rands, somebody can comment on that as well. Honorable Schlengwa, do we have the money? Our initial set of interactions around this issue is that SASSA might well have the money within its own pool, let's put it that way, depending on what we're talking about. So again, if our imperative is to pay the grants and make sure that nothing is happening that is disruptive of that process, we will have to come back to you and indicate whether something extraordinary had to be done to ensure that funds need to be found. But I think currently our view would be that, and this happens in many departments, Chair, where they say we have a squeeze, and then our officials help them to understand where monies can in fact be accessed from their own funds as well, and similar things would be done. In terms of the 6 options, the DG will address that question and which is the most favorable. But I imagine that the criteria will be cost effectiveness and effectiveness, and what are the current facilities available without building some extraordinary empire. I addressed the panic issue. I don't think we should generate panic at all. I'm sure that as a country, between the, as I said, judicial process, the executive process, and the administrative processes, we'll find a way to make sure that grants are paid on the 1st of April. and do so in as transparent a way as possible so that everybody's aware of how we have arrived at those sorts of arrangements. On the question of contract management and the expiry of the contract, I think, again, these are issues that SASSA is best placed to actually answer. But to the extent that the Treasury might have had a role in this, they will explain to you. SAPO, I've addressed this issue before. I think it might be very useful for you to actually invite the CEO as a recommendation. And I think that they have some interesting ideas which would enable them to play a good public sector role in this regard as well. The interest issue, as I said earlier on, we need to get more information in this particular regard. And we would share your concerns about the so-called cross-selling and the utilization of information about beneficiaries. And that is one of the issues that I think one of the parties who wants to join the process tomorrow in the Constitutional Court is raising as well, and we will be equally concerned about, because we believe that any information about the 17 million beneficiaries is the property of government. Is not the property of any private company. And that is a matter that needs to be settled in the course of the processes that we actually follow. Honorable Mente, again, you addressed the deviation issue, and we agree with you that this is certainly no act of God, as 8.2 indicates. But I think the CEO or acting CEO of SASSA have applied their minds to which part of paragraph 8 they are using as the basis for their application, and consideration will then be given to that by the relevant officials within the Treasury. We are not, inverted commas, giving money to anybody unless it is appropriated by Parliament itself. And so remember, the appropriation happens either to social development as a department or SASSA as an entity, and you as Parliament can hold them to account as to how that money is actually spent. But we do want to be frank with the public and yourselves that you face, and we face, a contingency as far as the 1st of April and maybe a few months after that is concerned, and special measures will have to be put into place to ensure that grants are in fact paid as all of us desire, that recipients must actually get the money that they are entitled to get through this particular system. You've pointed out that how long the tender process takes as far as Section 21 is concerned. I think all of those are issues that are not necessarily predetermined. They can be managed within different time frames and in a transparent way as well, which is what the court is probably going to require in terms of any new tender succeeding the current processes. The July bilateral, the officials will address that. I was not there. July 2016, which is a question you've asked. They've also asked questions about other meetings. I've explained that earlier on. CPS and the arrogance of the CEO, I'm sure he's getting the message from you loud and clear, so I don't need to add anything to that. So thank you very much for those questions. Honorable Kuno, thank you for reassuring us that we're doing our job. We'll hopefully continue to do so. You've asked about how people are paid. I don't think I followed that question, but if somebody else said, they can pick it up from us. Why can't post office do the distribution? I've addressed that question earlier on. And it'll be ideal if we could build a system of payment and interaction with the public around the post office and other financial facilities that we have, including some of the ideas that some of you have had about what kind of charges should commercial banks levy on what are the poorest amongst the South African society. And it's an issue that we would certainly like to pick up with the financial sector as well. And you could do that also. Some of them are sitting somewhere else in the buildings here, talking to the Standing Committee on Finance as well. Your point about pay points and mashonisas and the kind of role that they play, as do others, is a valid one, and I'm sure that these are issues that we all need to address as we go forward, not in the next couple of years, but in the next few months, so that we clear up who is entitled to what and who isn't entitled to what. And the financials of Net1/CPS certainly shows that they profit in two streams. The first stream is from the payment of grants, and the second stream is the so-called cross-selling processes as well. And that's very open. It's in the public documents that are available. The question of information I've addressed already. Honorable Chilwane, has SASSA CPS already agreed on the way forward? As I said, what we're looking at is a mechanism that will take us into the next few months and create an environment where there's certainty about the fact that people will receive their grants. Whilst that is happening, the task team that will work under the ministerial task team will consider other options which can take over from this temporary option. And thirdly, we have to wait for the court's judgment on tomorrow's hearings to see what other parameters that we have to work with. And I'm sure you'll be keeping an eye on that process as well. The SAPO issue also I've explained to you, and perhaps, as I said, SAPO is best placed to speak for themselves because we might not understand all of their internal mechanisms and how prepared they are and how prepared they could be into the future. Honorable Boy's questions, which is the last one that I'll be addressing. I've addressed the question of CPS selling other products, and we don't have any role on this because it depends on the kind of contract that was signed in 2012. And perhaps you want to get a copy of that contract and have a look at what kind of commitments have been made on both sides. I'm not sure if you've actually done that. CPS selling information, I've addressed that question as well, and it's a concern, as I say, that we share, but that information should belong to the state, and I think we should be absolutely clear on that. The procedures, as far as deviation is concerned, we've addressed as well, that as soon as possible we will give an answer to the application. But what we might want to just underline for you, there is this misperception that something needs to happen in the next day or two in terms of Treasury passing on money through the system. But remember the slides where we point out how money flows and when money flows. So money from the Treasury through the accounts held at the South African Reserve Bank only start flowing 3 working days before the date of payment. So there's no immediate urgency, even in the next week, which threatens the eventual payment of grants on the 1st of April as well. So that was quite a revelation for us as we began to understand that process. And that's part of the assurance that I think all of us should give to the public, that even that process is at hand and is under control as well. On the question of empowerment and so on, I'm going to ask the Deputy Minister to address that. But, you know, there is a challenge that we have politically in South Africa, because when we use slogans to communicate, then the slogans can become very misleading. So, you know, you are pink monopoly capital, and he's green monopoly capital, and she's black monopoly capital, and I can carry on, red monopoly capital, and so on. But that's not really the issue. The slogans are not the issue. What are the facts of life? What is the current factual situation about ownership patterns and benefit patterns in South Africa? And transformation is about changing all of that and giving new sets of opportunities to people who've been excluded in these processes. So I think all of us can play a very helpful role to demystify these issues for the South African public, because we can mislead them by using slogans. And it can mask all sorts of things, as you are discovering in your inquiries as well. So if I say that with great respect. So to round up, Chair, from my side, and I can come back at the end after the officials have addressed you, we should ensure that there is no crisis. We should ensure that there's a climate of certainty, that grants will be paid on the 1st, that there are political processes through the task team headed by Minister Hadebe and the technical team headed by his DG. And we've mapped out very clearly for you what we need to do as an interim measure and what we need to do in the medium term. And we've also outlined for you that a lot will depend on the Constitutional Court's judgment arising from the hearings tomorrow. We've also indicated that information about beneficiaries should belong to government, not to anybody else. And we join you in sending a message to the shareholders of this company that they should become more respectful and understand the sensitivity of the issues that we are dealing with, so that, because this is not just a money-making exercise. Part of this, as the court says, is that once you enter into delivering a constitutional right, which is what CPS is doing, they also become an organ of state, so to speak. And as an organ of state, they also have an element of not just accountability to shareholders, but accountability to the South African public as well, in terms of the way utterances are made. And I'm sure with you we can communicate that loud and clear. So let me move to my left now, with your permission, Chair.
Yeah, I like movement to the left. I thought you said the Deputy Minister will talk to something.
No, I was going to come later anyway, but I can just summarize. I mean, in Green Road, I think the major shareholder is Remgro and Green Road Investment, and you've got also PIC participating and a couple of others, all South African companies in Green Road. My understanding of CPS, I think the larger portion of it is owned by Net1, and then there's a smaller portion of a whole range of local players. You must remember that in the constitutional court process, the issue about the credibility of the empowerment credentials of CPS is also a subject matter being looked at. Thanks.
Thank you very much. I mean, just riding on what the minister was saying on the budget, and it's connected to Honorable Shangwa's question. More often than not, in the conversation, and because we get involved, people think that this is about money and money not being available. I just want to make this point very, very, very clear. There is money for paying the grants. There is money for paying whomsoever pays the grants. Parliament has before it an appropriation bill that will then legally authorize us to draw that money from the National Revenue Fund and to pass it to social development. The issue is not about that money. If, for instance, let's say, and it is in the very unlikely event, I want to underline and bold, in the very unlikely event that the money that's earmarked to pay the service provider were to get exhausted, which, if it were to happen, it would be next year. In other words, towards the end of the financial year, because the 2.3 billion, I think, is the money that's set aside for this now, right? You can just divide it by 12, roughly. It gives you a sense. It is a lot of money. It would take a long time to exhaust it. But if it were to be exhausted, in the unlikely event that it were to be exhausted, there is a route through which it can be augmented, which is first looking within the department or SASSA. Is there money somewhere that can be moved to this bit? And the minister said there was lots of that. And secondly, if you go beyond that, then it can be looked into the system. So I say this because before you realize it, we think that there is a problem. There isn't a problem of money. We are not here because, as Treasury, to talk about that part at all. Let there be no confusion about it. Because before you realize it, because we're here, not you, because you know the process, but elsewhere in people's heads, they say, these heartless people, there is no money to pay the grants. The money to pay the grants is there. The money to pay a service provider to deliver the grants is there. What doesn't exist is a contract to make sure that those things happen. That is what is at play. So it's very important to clarify. Now, there was a question asked. We frown at illegal deductions. We have a process even now, Honorable Boy, to try and understand more deeply, what illegal deductions exist in the system. Why is it that, because we've been trying to tighten the noose on these things and, tighten the regulations, but every time you write the rules, then people cleverly find a way to find a gap. And you are right, they are offensive, they are not supposed to happen, but and we have a role to kind of help define the rules of the game insofar as that is concerned. But we're dealing with people who always look for opportunity to find a gap in the system. I think it was Honorable Mende who said she didn't understand because the number that was used as CPI was higher than what she knows. You are right. It is actually higher than what you know. I suspect that whoever is thinking about that number does not separate sums from averages, right? If you say that CPI is 6% this year and 6% next year, you are cheating me if you say that, oh, it's 12% over the 2 years, give me 12% this year and next year. I mean, surely, even with Bantu education, we understand the difference between the sum and averages, right? So you are right. There is a bit of that confusion there, but it cannot happen, at least with us. We understand it. But now, Honorable Protestant asked several specific questions. Some of them will be answered by the acting CPO, but one of them related to something that is belonging with me and Mr. Mkhajani here. Insofar as several meetings, several seems to exaggerate it a bit. We were not there. To my recollection, there aren't several meetings to which we were invited, which we didn't participate in. I remember only one. And the meeting I remember, I call it one meeting, but it may have straddled days, was in relation to negotiating with CPS. And we said, we wouldn't be involved in that. And we have, I think you have picked the reasons for it already. It had nothing to do with saying we're not willing to help in this case, but we thought that it was not okay for that meeting, and you would understand why. But if you want me to elaborate, I can. Right? So that's the, we couldn't participate in that. Other than that, I've got no recollection of another meeting. Okay, he will talk, he says there may be another one that he will talk to. Now, there was another question from Honorable Ko about the amounts about what gets paid is per recipient. It can be very confusing. So the arithmetic does not move from 1644 to 17 million. it moved to 10.2 million, right? Because as the minister was saying, a recipient could conceivably receive grants for more than one person. So you don't pay 16 Rand 44 per recipient. So the arithmetic works the other way. On the issue, and I think this is perhaps the last one for me. The other issue that arose was the issue of why am I losing this now? Oh, the receivables. Couple of things with this. You see, some of this stuff relates to old order arrangements. You may recall the delivery of social security grants used to flow to provinces, provincial departments of social development before SASSA was established, and then it would end up in banks. A lot of the time, this is just a function of how the contracts were structured for a start. What are the arrangements at the end of a period? In other words, you transfer the money because payments for grants are due. Then when the payments are done, all of them, there's supposed to be a reconciliation process to say, you gave us money for 10 million, I mean, I'm using the number now incorrectly because it's the current one, but for 10 million beneficiaries, X% of them didn't claim their money. Then there has to be an agreement how you sweep it back, and with interest and all that kind of stuff. But it's not as simple as I make it, because I mean, I don't know why I'm complicated, but let me just illustrate it. Because sometimes the money gets into, say, for instance, in a person's account, the person is still alive, but very ill, let's say for 2 or 3 months. So for as long as they live for those 2 or 3 months, the money is theirs, all right? So when they die, it belongs to their estate, at least the part that was paid when they were still alive. It cannot be a matter of you just send it back. You see those complications. So that is where that issue lies. It's not open crookery, as I understand it, where people just sit with it. Now, it requires some conversation to say, to the extent that that bank is sitting with the money, which one belongs to the estates of the people who are deceased, if at all, and which one has got to come back, how much interest has accrued to each portion. That's the first part of it. But a very important part of it, and this is preliminary, but we will give you the information when we have it. We're asking the banks and the institutions that have been mentioned. The numbers that we have preliminarily got are far smaller than the numbers that seem to have been floating around. For instance, in one instance, without mentioning the names, the number seems to, there have been a 500 million number versus 49 million. Now you get a different picture once you, but as I say, it's preliminary, it needs to be verified, just so that I don't lie to you. But I'm just saying we are following it up, and once we know the details on it, and we have found a way, because it is something that must be sorted out, it can't be left hanging forever, we will come back to you.
Chair, just a quick clarification. The thrust of the question on that bank issue is that was used as an excuse why the banks were not engaged. Those arrangements, would they affect the good standing of the banks? Let's put it that way. I understand that you're waiting for money and it's complex. Would it affect the good standing of the banks?
No. The ways to disqualify a bidder are more elegant than that. I can't look at your forehead and say you shouldn't bid. No, I'm actually very serious about it. But I mean, you've got to have a due process to arrive at the conclusion that these ones disqualify. It can't be just you get my point, right? Yeah. It can't be arbitrary. Thanks, the minister is helping me with English. It can't be arbitrary. So there can be, I mean, to my understanding, I don't think there is a ground at this stage simply to say, this, I mean, in this case, banks don't qualify. In fact, just to connect it to the other point, which the DM had whispered to me, you see, what happens is, because people live within proximity of ATMs, right? Any mechanism that enables people to get the money from an ATM is hard to rule out. I hope I'm clear here. So that's why, for instance, the thing about the Green Road, once the money has sat in the Green Road account, which is a bank, then people have the ability to access it anywhere where there is an ATM. Correct me if I'm wrong. So that's the essence of, you get that point. So then the issue arises. Maybe I'm saying too much now here, but the issue then arises, given the fact that you face these what do you call them, the charges when you use a different ATM. Given that you face those charges, is it not better, if it is possible to do it within the framework of the law, to transfer his money to the bank where he has an account, and then his money to the bank where he has an account, rather than have them face those charges? That's a very valid question. It also connects to the question that was asked, can you negotiate with the banks to give favorable terms to these people? Banks only give favorable terms to their customers because they cannot know that, I mean, there might be a way because of the card and stuff like that. But yeah, you can negotiate it. There can be a way to negotiate it right across the board. I mean, in the context of the creation of the Mzansi account of many years ago, it became obvious that some of these things can be negotiated within limits, of course.
All right.
Thank you, Chair. There was a question in particular on the 28th of July and that meeting. Now, we engage departments all the time and entities all the time, every day, in some cases through telephone calls, SMSs, WhatsApp messages, and informal meetings. Now, in particular on this meeting with SASSA, we had informed them a month in advance, by the way. We wrote to them because it's a formal engagement, it's a budget bilateral whereby we have to look at the spending to date as at that time. We have to look at what they are putting together as a bid for the 2017 budget. So we wrote them a month in advance. In this letter, we would have said, for instance, we give them items that you want to touch, over and above the agenda item where it was just SASSA, its readiness, medium to long-term vision, and then issues around the banking solution, etc. Over and above, in this case, we gave them a 1 page of questions in relation to issues around the biometric, issue around payment method, and how funds are going to flow in terms of the new payment model that at that time they were engaging on, because one of the key issues was a budget bid that they were making, in particular for the new payment system that they were developing. So after such a meeting, we'd engage. It was a day's meeting from 11 to 3:30 in the afternoon, and then we capture proper good minutes where we share with them and so on. So it's one of those over and above what I said, the engagements. Now, in such bilaterals, as members would imagine, we take our gloves off, and they also take their gloves off. We engage thoroughly. It's closed sessions, closed meetings, whereby we kind of open up, because you remember a team of budget analysts in the Treasury engaging on every single number and idea, including things, and in these such engagements, would have picked up on issues that they might have told us in the previous engagements around their readiness, around what exactly they want to achieve, and we'll ask questions. Now, it's interesting that all of the issues, most of the issues that members are asking us today are issues that we'll have engaged with on whether it's deductions, in terms of just understanding, because either would have a good budget analyst is the one who'd listen to a TV, read newspapers and so on, and ask that as per an article on such and such a date, I picked up these issues around Green Road and the cash CPS and deductions. What is your view? What are you doing to actually? And it is in those engagements that we help each other in terms of how do we implement the budget moving forward, and make sure that some things happen. So in some cases, most of the time, we obviously exceed our mandate as a Treasury in engaging on issues that they would be responsible. But at the end of the day, we would agree that it's matters that they need to take forward, that in future engagements, we kind of get proper feedback. Now, in terms of the issues that we would have agreed on, or for them to engage and look on, they would be better placed to maybe update, because this is, as I'm saying, it's a rolling engagement all the time. if you look at July 2016 last year, and in terms of the timelines that we've presented this morning, various other processes quickly emerged leading to December and leading into those various engagements specific on the issues of payment and whether they will be ready to pay on the 1st of April. So the engagement is continuous and it's always dynamic in all instances. Thank you, Chair.
Chairperson, if I may respond to some of the questions that honourable members have raised, and specifically Honourable Braceth. Without stating, at risk of stating the obvious, I'd like just to explain, before I answer a quick yes or no, how the process should work in a department when a deviation is submitted. The procurement system consists of 3 committees: a specification committee, evaluation committee, and an adjudication committee. And the reason why specifications would be very necessary, it determines the kind of contract one would enter into. So some of the considerations would be, is this a full sum payment? Is it a time and material payment? Is it a fee contract? Is it a combination? Or is it a time-based contract? Provisions are made in the accounting officer guide to determine the aspects of quality, of specification, and it's necessary, even if it's a sole source or a single source, which is often the reason for a deviation, to formulate those. Once a specification committee has assessed this, then the sourcing part could start where a bid is invited. Even if it's a sole or a single supplier, a bid is always sourced because that forms the basis of a contract. Today we have the benefit that my colleague Solid Chitanganu is with us. He has specifically assessed the cases of the work streams, and maybe we can provide, Chairperson, some insight what we have done since we received the application on the 23rd of June and eventually responded at the 19th of January. We will shorten, but then in the interest of time, maybe I could just highlight the process that we followed. We asked for additional information to make sure that it's very clear that this will be in the interest of delivering a work stream outcome. At the time, it was clear that there is going to be no competitive bid, and SASSA would build their own capacity to make the payments. At least in June, that was our understanding when we received this application. We received additional information that we requested in writing to explain why these prerequisite skills would be necessary to fast-track the work streams. And upon receiving that clarification, we approved the deviation, provided that the cost is reasonable, and provided that we have printouts of the timesheets and detailed invoices generated by these consultants. Chairperson, that's the process we followed to consider the application, and there was communication between ourselves and SASSA seeking that clarifications.
And those clarifications were given?
They were given, sir.
To your satisfaction?
That made sense that we had a continuity issue that we had to address. Yes, sir.
All right. Yeah, let me give Stangano briefly. And I think we should round off. Omsanda.
I just want to, thanks. I just want to clarify the deviation for the work stream was not approved or condoned. And the background is that after they deviated, the deviation started in July 2015. And that process went on until the contract 3 contracts were signed in June 2016. Therefore, there was no way where you will say it was impractical to invite competitive bidding, because they had a period from July 2015 and the contracts for the work stream were only finalized in June 2016. Therefore, for 12 months, you can't say I didn't have time to invite bids. Therefore, SCALC is mixing the other issues because we have so many, but that deviation has not been approved, and we don't know whether the Auditor General will declare it irregular expenditure. That's the fact that I wanted to clarify. The 316 million also that Ross referred to, it was declared irregular expenditure because the deviation which the CEO, the former CEO, first verbally approved it and later in writing, it was declared irregular expenditure by the Auditor General. But then, after that, corruption was alleged that this is not irregular expenditure, it's fruitless and wasteful expenditure, and they are taking SASSA and CPS to, the matter is in court now. They are saying CPS must refund that 360 million to government. Thanks.
All right.
Chair, I just need to clarify because we've got a material issue here. So on page 30 of this report, where it says that the work streams were approved, which is what Mr. Human says, Solly is saying something completely different. He's saying they weren't approved for a year. So they can't both be correct. Can we just get clarity from who is correct? I fully accept that maybe Mr. Human mixed it up with something else. But can we just get clarity, please? I need to know.
Well, I would imagine that Chitangano gave the clarity, since he's the man, even SCALC said he's the man who dealt with it. And right, I want to check.
Chairperson, the clarification that I think we required, I'm specifically referring to the letter that we submitted on the 19th of January, pertaining to the period for the procurement process for the application received on the 23rd of June. That's the period that I'm responding to, and I'm quite sure Solly has clarified this comes from a previous financial year where there was a 12 months that's not covered. I hope that clarifies the matter sufficiently. So the end of the financial year 2014-15.
This is not a hard thing. It's record. There is an application, there's a response to it. We'll give them to you. Because now we can be mixed up because we're talking about different time periods, because there are several applications and maybe several, more than one application and responses. You know, then we talk past each other, but it's records, they exist, you can't change them. They've occurred in the past.
All right. Okay, no, that's fine. I want us to round of comrades. I'm looking at time. So let us be brief because we have exhaled already. Comrade Boy, Comrade Kekane, Comrade Kuno, and that's it. Okay, right. Yes, Comrade.
No, Chair. We wanted to say that the Minister has answered many questions. And the spirit that the Minister has presented of collective, in his presentation of saying that they are applying their mind collectively, they're working as a collective here, should be the one that we accept as a committee and follow up the details that we are interested in to continuously, because we are not going to move our eyes off the matter itself. As you have said, DG, it's not just about the money. We would love really the Minister to resubmit to us the contract so that we can also see the other contractors, how do they talk to each other and how do they close up to the concerns that we have expressed, that we have really expressed to you that concern the security matters of where the data is and how do you go and close that particular one up. And also to know exactly the detail of the financials that how the financials themselves are being spelled out. That 22 versus the 16, how that increase is beginning to happen. I do think where we are seated that we're quite happy about the information that has been provided, and we just build upon it as the case unfolds. We are all are waiting for the Constitutional Court. I'm sure this is what Kuno was trying to express, that we are not saying do things outside the law and how the law has been crafted. We are raising our concerns because we are representing our own ordinary people, and we would love to see to it that the matter be resolved in a manner that will save all of us the embarrassment that we have foreseen. Thank you.
Okay, thank you. Comrade Kekane.
No, thanks, Chair. I think Treasury has assisted us in demystifying this whole thing, because the perception out there was that Treasury is not cooperative on this issue. Now that Treasury has given us the assurance that grants would be paid as from the 1st of April within the parameters of the law and the budget, I am confident that that would happen. But on their presentation, unfortunately, Treasury has opened other loopholes. That simply means, as COPA, we need to further investigate, that is, these issues. We need, that would be my proposal, that we need to invite the CEO of SASSA to try and close certain gaps that Treasury has opened, and also the issue of the post office. My proposal would be, maybe let's look at inviting them, that is in one session, and deal with those issues before we make a recommendation.
Okay. Comrade Kuno, Lengwa and Ross, and then we will be done for the day.
Thank you, Chairperson. I want to add on what he has said, that we need to have the CEO of SASSA to come before the committee as part of our investigations. And yeah, but Chairperson, we need to help each other, South Africans. And I think where one needs praises, like my colleagues have said, really thank you, Minister, and the way, and your team, and the way they've really answered the questions. That's what we want. But Chairperson, what I see a problem that can be solved together is miscommunication. I think there's miscommunication within government departments, and it's why about sabotage?
No, continue.
Yeah, and yes, okay. If that miscommunication can be rectified, Chairperson, I think the problems that you spoke about, the concerns that you spoke about earlier on, of inartis and other things that goes to court, I think we can deal with them. If procurement office, for instance, DG, can be beefed up, because I mean, if you look at the mandate, it can actually help all these departments that we are talking about, because it will be checking accountability and how people are spending monies of government. So if it's not beefed up, we're going to sit with a problem, not only SASSA problem, but tomorrow we'll be dealing with another problem as well. And if you look at PFMA page 80, section 79, it says that National Treasury may on good grounds approve a departure from Treasury regulation or instruction or any condition imposed in terms of this act, and must promptly inform the Auditor General in writing when it does so. Because I was trying to think, you know, as the Minister was presenting, but do they have teeth really to bite? And the PFMA gives you teeth to bite, but why are you not biting? And the problem, which is what we've been emphasizing, Chairperson, is that most of the departments, they don't want to follow what is in the PFMA. And I'm saying now today, because the Minister is here, we need to have a workshop on PFMA with all the Director Generals, or what you call accounting officers, so that when we finish that workshop, everybody can be on the same line. Because the problems that they have when they come before SCOPA is because they do not follow PFMA. And the only way that you can think of is that they don't know what is in PFMA. That's why they don't want to follow the regulations So I'm just appealing to the minister, if that can be done together with the members of parliament, I think we can do, we can correct some wrongs. Thank you, Chair.
All right. Hlengwa?
Thanks, Chair. I'll be very brief. Chair, as I indicated earlier on, today, as far as I'm concerned, the presentation by Treasury unraveled a lot of confusion on this matter and sort of gave an indication that at least there's some clarity now in terms of where we are. Chair, I want to make the suggestion that let us, as a committee, not approach this issue of SASSA and the payment grants now in a piecemeal fashion, and guard against the reactionary sort of intervention. We need a full-scale, structured inquiry into this, so that we can actually drill down into all the matters. So I'm just making that proposal, Chair, that as a committee, let's apply our minds so we can bring this matter to a logical conclusion, logical understanding. I mean, because in the final analysis, value the money is there. The money will be paid. And none of us have disputed that. But we are concerned about due process, conduct, leadership, and whether there's any footsie that is being played with service providers, so we can actually get to the bottom of how we ended up having a political gun held to our heads. Because otherwise we run the risk of dealing with this matter ad hocly, as and when matters arise. Rather, let us just dedicate ourselves, find the parliamentary mechanisms applicable, and have a full-scale inquiry on this. Thanks, Chair.
Okay, thanks. Ross?
Thank you, Chairperson. We welcome the presentation from Treasury. We're also welcoming the efforts made by Treasury in very difficult circumstances to make progress, to see that at least we address the core of the problem, providing the grants to 17 million people. And we appreciate the interventions made by Treasury. We are, however, concerned about the disregard from the Minister of Social Development for Treasury regulations and the disregard for even court rulings in the past. And so we would like to join our colleagues in terms of agreeing that a full inquiry should be conducted, and we propose a full parliamentary inquiry in this regard. Thank you.
Okay. Thank you very much, comrades. I just want to check, Auditor General, I think there was a question around receivables. I know Treasurer responded to it. No, I'm checking with the Auditor General. That's why I'm saying I know it was responded to by National Treasury. I just want to check if the Auditor General would have something to say around it.
Okay. Honourable Chair, it's not reflected in the financial statements. The source of the receivables is, as the Minister and the DG have indicated, it's with regard to old beneficiaries receiving grants. So that's with regard to that specific question.
All right. No, that's fine. I just wanted to make sure that we did not leave you. Once again, Comrade Minister, thanks very much to you and your team. Before I hand back to you, if there are issues that were spoken to that you may want to talk to, I think I'll probably be speaking for all my colleagues to say the bravado that was displayed here last week from that chair, it appears that it was totally misplaced in terms of the sense of having everything under control and the processes unfolding as it was being articulated. Because I think what has emerged here is that the process of getting a new contract was taken away not only from the CEO to the Minister. It looks like now Cabinet has now taken it away from the Minister now to a team now led by Minister Jeff Hateb, indicating that indeed there is a crisis of confidence in terms of how this simple process have been managed. I think we can't overemphasize our outcry around this company called CPS and how any self-respecting South African would want to perpetuate this insult called CPS. It just boggles my mind. Especially people who would say we fought for freedom and then behave in ways that are totally contrary to anything that would. Well, the Constitutional Court process, Comrade Minister, and I think I'm speaking for myself, and I'm sure for my colleagues, you see, at some point we're going to complain about judicial overreach, and yet our own incompetences actually invite the courts into the realm of, executive functions. Totally unnecessary. And I don't know if the court says SASSA is in contempt of the court, I don't know what you are going to do as cabinet if it makes that pronouncement. Because it made a ruling some years back and you did all the things you were not supposed to do. So I just don't know, but anyway, it's self-created. And lastly, I think as my colleague said, we're very clear that grants are going to be paid. That's not the point. That should not even be a point of discussion because that is what must happen. I mean, we mustn't lower the bar to a point where when you pay grants, you say, I've achieved. You haven't achieved anything. But our main concern is, will this payment be done legally or illegally? That's the fundamental question. And will it be done within budget or not? Because the figures you're talking to about interest payments to loans in the budget, those are very, very worrisome figures. And we therefore can't be using money recklessly. So, but we thank you very much for these inputs. I think comrade suggestions about let's do A, B, C, D, I think that will require us as a committee to say, what is it that we would want to do in relation to these matters. But let me hand over to you, Comrade Minister, if there's anything you would want to talk to before we call it a day.
So firstly, let me thank you, Chair, and the committee members for a very useful set of interactions, and I'm glad that we've helped to, as some of you said, demystify the issues to some extent, because transparency is a key part of accountability. And if we are unable to put in very simple terms what might appear to be complex initially, then we're not able to interrogate it in the right kind of way. So thank you, and I want to thank my colleagues for all the hard work that they put in to get this presentation to you. Secondly, Honorable Kunu makes two interesting points. One is we have teeth, use it. But you see, when we use the teeth is when the other narrative starts, Treasury this and Treasury that. And let me be frank, unless we create an environment in South Africa where, as some of you have said earlier on, do the job that you are assigned to do by the Constitution and the law, and accept the fact that all of us have our respective roles, we then get into the sloganeering that I referred to earlier on. But behind that sloganeering are also particular objectives. Weaken the Treasury, take over the Treasury, etc., etc. You've all heard it. I don't think it's child's play at the end of the day. And it then makes it difficult, Honourable Member, to use the teeth. But it takes a tremendous amount of integrity and courage amongst the officials to even begin to show the teeth, let alone use the teeth. Which then brings me to the question. You see, the PFMA, whilst it places certain responsibilities at the door of the Treasury, actually also equally, I think Section 50 onwards, spells out very clearly what the responsibilities of accounting officers and executive authorities are. Right. Now, we refuse to take on the responsibilities of others. They must, my Director General often reminds me of that. Let's understand the law and what each of us is obliged to do. There's no big brother, big sister phenomenon here. If all of us, as you said, follow the law and do what is required to be done and follow due process, without too many other obligations being brought into the picture in terms of extracting money from the state for wrong purposes, let's put it plainly, then life would be actually much more simple. And we would have much easier meetings, both for yourselves and for others as well. So you might want to keep that in mind. So it's not a question of whether you understand the law. It's a question of whether you want to abide by the law at the end of the day. And if you just agree to abide by the law, and where you can't, be transparent about it and get the consent that's required. That's why the word deviation appears so many times today, because it does say sometimes the law is a bit of a stricture in the circumstances that you have to operate in. Then do the things that are necessary to account for decisions that we actually make at the end of the day. Nonetheless, if you think there's wisdom in getting accounting officers and so on together, we will certainly offer you every cooperation that you might actually require. At the end of it all, we shouldn't create an environment where the separation of powers, as you correctly point out, Chair, is called into question. But the separation of powers doesn't have a Chinese wall between it either. And there are going to be gray areas into which society will find itself from time to time, and we'll have to learn to cope as a country in defining our own rules of the game in terms of what we do, so that we have the right checks and balances in place on the one hand, and demonstrate what it means to exercise good governance at the end of the day. So once again, thank you on behalf of my colleagues and myself for the interaction. And if there's any other information we can provide to you, you're most welcome to ask. But I think a lot of that resides elsewhere in terms of your further inquiries. Thank you.
Thank you very much, comrades. Remember, tomorrow it's Transnet. Thank you very much.
All right, there you have it, Minister Gordon briefing the Standing Committee on Public Accounts on the SASSA matter. Also joined by his deputy, SABC Jonas, the Minister making submissions on what Treasury's role is in this issue, and then SCOPA members putting their questions and issues forward to Treasury. So that's what we've been hearing. What we do know is that a new technical task team has been appointed to take forward the discussions on the payment of grants and the negotiations. The Minister has also said that he's confident that social grants will be paid out on the 1st of April. So the Minister saying that between the judiciary and the executive, a way will be found to pay the grants in a transparent way. So it's all about the legality of this, not whether or not grants will be paid. With that, he's added there's a question around where the monthly interest is going from the 11.2 billion that's been allocated to social grants. It's supposed to be going to government coffers, so it'll be interesting to see what comes out of that issue. Also, he added that once the grants have been paid, there will be more than enough time to sort out remaining issues. So, as I say, the main issue, not whether or not grants will be paid. We know that they will be paid on the 1st of April, but the question is, will it be done legally? So we'll get more on this coming up. We'll take a short break. Stay with us. You're with the Midday Report.